I need to mention one.
It is not the mentioning date.
Extension of interview.
When expiring?
Today, my lord.
Today.
Yes, my lord.
So why it was not mentioned?
No, my lord, like last mention was the 19 January, my lord.
Yesterday.
My lord.
Yesterday it was mentioned.
No, 19 also.
Yes. That's why I directed the matter to be mentioned today. When the interim order was last extended?
No, my lord.
Tell me when it was last extended.
This is first time, my lord. First time.
Then when the interim order was passed?
31st 12 2025.
By this court?
No, my lord. My Justice Vishwarup Chaudhary.
Well, tomorrow extension of interim.
Get full, my lord.
Call the list. Item number 1.
My lord, will kindly excuse me for appearing online, my lord. I am away for SIR hearing. I appear for the state.
Order copy টা করে Now affidavits are complete.
My lord, my opposition is almost complete, my lord. Kindly grants me 1 week extension because there was some
But you
modification.
appeared before the division bench.
My lord,
Division bench requested this
my lord,
court to make an
It
endeavor
was
to
ready, my lord.
hear out
Certain,
the matter in the month of January.
my lord, it was ready. Certain modification needs to be done in the affidavit.
Why you have not filed it? Division bench passed on order 15 December
But
2025.
I bow down, my lord.
From the department, a report has come yesterday to my officer to take necessary steps after going through the order.
Kindly
Passed by
grant
the honorable division bench.
a week's time. By that time, my lord, the affidavit will be ready and will be served upon my learned friend, my lord.
Commission has served affidavit. This is our reply. Commission has served opposition.
Commission has not filed any
Yes,
opposition.
they have served to us. We have served. We are filing
Reply.
reply today.
But state has not filed
It
any.
has not yet.
Who is appearing for the state? Vivekananda Bose. Where is he?
But he is appearing.
My lord, I am appearing. My lord,
Have you
appearing
filed
for the state court
affidavit in
online, my lord.
opposition?
My lord, will kindly excuse me. I am away for
Have
SIR
you
hearing.
filed affidavit in opposition?
My lord, no, we have the state.
Yes.
My lord, the state has not filed any affidavit in opposition. My
You
lord, will
don't
kindly
want to file any
appreciate.
affidavit?
State, my lord, I believe I am audible, my lord.
Yes, you are audible. Please
Yes, my lord. The
submit.
state does not want to file any affidavit. My lord will kindly Yes, my lord. I am submitting, my lord, that the state does
So
not, my lord,
state
want to
doesn't
file an
want to
affidavit.
file any
Subject to,
affidavit.
my lord, directions of you. Yes, my lord, because
Yes.
the initiating authority is, my lord, the High Court, and the conducting authority is the Commission. The state hardly has got any materials to place before the court. That submission, my lord, with the instructions.
You whether High Court wants to file
My lord,
affidavit?
we would like to file an affidavit. Otherwise, my lord, the interpretation of the judgment, the applicability, that is for your lordship to decide in this matter.
No, question is whether you want
My
to
lord,
use an affidavit or not.
kindly. 1 week time, my lord. By that time, it will be ready.
So by that time, month of January will be over.
But the examination has already.
Who should have filed it, considering the in terms of the order passed by the Honorable Division Bench.
I apologize, my lord. Certain modification needs to be done. That is the reason, my lord.
File your affidavit.
Affidavit is a copy there.
মনে করে রাখতে হবে না?
What was the order passed by Division Bench, Mr. Lahiri?
My lord, there was a direction by the Honorable Division Bench at 6, paragraph number 5, my lord, considering the nature of case, we request the learned single judge to endeavor to decide the matter expeditiously, preferably in January 2026, as already recorded in the impugned order.
So why you have not mentioned it in the first week of January?
My lord, we actually waited for the normal.
Matter is appearing in the list. Why you should have brought it to the notice
Yes,
of
my
this
lord.
court.
Since it was in the list, I did not mention.
You
because-
mentioned it on 19th
Yes, since it
for
was,
the first time. Why?
it was already in the list, we did not trouble your lordship. I
Then
thought-
this court could have made an endeavor to
Yes, yes.
direct the High Court to file the
Yes,
High
yes,
Court administration to file affidavit as early as possible.
Yes, my lord. Yes, my lord. Since
This court was functional from 2nd of January,
yes, yes, my
and you mentioned it on 19th January.
lord. Since it was in the list, we didn't want to trouble your lordship. We thought it would be
Why
taken up
at the fag end of the
middle of
month? Why not middle?
almost middle.
No, not
At
middle.
the-
Why?
No, we thought
It was your appeal. You obtained
yes,
an
yes,
order from the
absolutely.
order of the from the
Absolutely,
division
absolutely,
bench.
absolutely. No, we thought your lordship will take it up in natural course. But
No, there is no indication in the list that hearing matters are to be
no,
taken
no,
up.
not at all. But there
So
is
then-
since it was in the list, we did not trouble your lordship.
You have
That-
forgotten.
No, no,
Yes, yes.
I did
Or you have neglected.
no, my lord, I just tried.
Issue.
my lord.
Section officer, mandamus section. VDA letter dated 19 January 2026. Forwarded the copy of the order dated 15 December 2025. Passed by the Honorable Division Bench on an intra-court appeal being MAT 2130 of 2025. Within bracket Shayan Sochin Basu versus the state of West Bengal and others. Stop. On being informed about order dated 15 December 2025, after receiving letter dated 19 January 2026, Assistant Court Officer of my court placed the order of the Honorable Division Bench dated 15 December 2025 before me, and before me. Stop. In addition, there are two learned advocates representing the writ petitioner. Mentioned this matter for the first time on 19 January 2026, and court was informed of the order dated 15 December 2025 passed by the Honorable Division Bench. Stop. Matter is accommodated in today's list under the heading to be mentioned, quote unquote. Matter under writ petition করে দাও. Stop. Next paragraph. Affidavit in opposition is filed on behalf of West Bengal Public Service Commission, and affidavit in reply is filed on behalf of the petitioner, and same are taken on record. Stop. Mr. Devashish Banerjee, learned advocate representing, next paragraph. Mr. Devashish Banerjee, learned advocate representing High Court Administration, has prayed for extension of time to file affidavit in opposition, which is not opposed by the learned advocate representing the petitioner. Stop. Mr. Vivekananda Bose, learned advocate representing state respondents, appears on virtual mode and has submitted that state is not willing to file any affidavit in opposition to this writ petition. Stop. Time to file affidavit in opposition stands extended by 7 days from date. By 7 days, and affidavit in reply thereto, if any, be filed by 7 days thereafter. Stop. Extension of time to file affidavit in opposition is peremptory. Stop. Next paragraph. Though I was thinking that the matter to be placed for hearing tomorrow at 3 p.m. No use of it.
अच्छा
5th February at as 3 p.m. fixed matter.
My lord, before your lordship moves on to the next matter, my lord, may I make an innocuous prayer before your lordship? Your lordship will kindly recollect that
Let the
on
matter be
last-
called on. Let the
No, my
matter
lord.
be called
No,
on.
no, not on the merits or anything, my lord. On the last
Which
occasion,
matter?
my lord,
Which
my lord,
matter?
this matter only.
Yes,
81.
yes,
My
yes,
lord, the state had, my lord, handed over a copy of the rules to your lordships, my lord,
yes.
for perusal. My lord, we would seek your lordship's leave to, my lord, take back the copy, get xeroxed and place it before the
Yes,
court
yes.
once
দেখো
again.
কোনো রুলস ভেতরে থাকলে ওদের দিয়ে দাও, ওর জেরক্স করে আবার দিয়ে দেবে।
We do not have
Under the heading hearing.
Lord, that is why I had to make this request.
But keep the copy where I put
Gratefully, lordships.
my notes.
Yes.
Yesterday in one
Yes, my
matter,
lord.
original copy was filed before me
Yes.
on behalf of the Central Union of India, and perhaps the learned advocate was permitted to take it back for getting Xerox copy, and after making it
Yes.
Xerox, as a Xerox
Yes.
copy was
Yes.
supplied to my officer
That is
without
unfortunate,
any
Lord, but
supporting
yes.
document.
Lord, Miss Moshomi Banerjee is there
Yes.
with me
Yes,
in
yes.
your lordship
Instruct
court.
your
Lord, she will
junior
take the copy and
accordingly.
return it back. Yes. Gratefully, lordship. Obliged.
Item number 2.
Participated
এটা can কি করে
process.
এটা can
Oh, the can was for addition of party that was filed by someone else who was supporting us in the point of maintainability. That has been disposed of. Lordship has already had. Now kindly comes to page 15. This is the initiation of recruitment process. May I just place?
But perhaps this can was not disposed on last occasion.
Yes, Lordship. And my love, in this regard, I am seeking 1 week accommodation because I have not yet get the instruction from the
Can is for addition of party supporting us in the
Judgment you have received.
yes, yesterday last night.
can may be disposed of. Can is
Normal.
normal order. Formal order. And can it
Submitted, Mr. Laidi, that the can is maybe disposed of, but that is not gone down in the
In-
judgment.
Yes, yes.
That has not gone.
Mr. Shamim was appearing. Shamim
Yes,
Ahmed,
yes,
senior
yes,
Shamim was appearing.
yes.
Well, kindly comes to page 50.
So can it may be disposed of? There is nothing in it. Yes.
Now, no one to press also. Page 15 is the advertisement, initiation of my lord recruitment process. It's by the Public Service Commission. Instructor in the following trades at government industrial training institutes under the administrative control of the Directorate of Industrial Training under the Technical Education Training and Skill Development Department, Government of West Bengal. So these are the instructions. We are
It's a recruitment notification.
Yes.
What
We
is the
are
date of this notification?
2020 notification. The dates do not come in the notification. It is the place where it has to be clicked and thereafter the notification comes. The notification itself.
Page 22, commencement of online application is 28 January 2020.
Yes.
So therefore, the date is must be prior to
Must be prior
28 January.
It's an
2020. So
advertisement
why you
of
are coming today?
Yes, that is the reason. I'll show. May I just, we are concerned with regard to the category, second last category, refrigeration and AC mechanic. So the petitioner participated in for being recruited under OBC A category. Kindly see there were 2 posts reserved.
Yes.
Now, my lord, the recruitment process went on. We have participated in the, my lord, written test, practical test. The results of the practical test came out at page 49. That is on 9th June 2025.
Yes.
9th June. Kindly sees my name appeared as item number 31. May I just read the, my lord, announcement? Schedule of interview for recruitment to the post of instructor in the trade of refrigeration and AC mechanic at Government Institute or such and such. I am skipping over. Candidates as shown below have been considered eligible to appear in the interview after qualifying the practical test. So till practical test, I have participated, qualified. But next is the, my lord, cause of action. I've already. List of recommended for appointment of 9 within bracket 3 reserved for SC permanent post of such and such in such and such. And my lord, kindly sees category
Page
page 50.
Yes.
Now in OBC A category, no one has been recommended. But I have participated, I have completed till practical. Even if I get 0 in interview, I may be referred because I have
Yes. 0.
even if I do not get any marks in the interview. Say for instance, I don't get any marks. I got some marks. That marks have not yet been published. No one else had kindly comes to page 49 in OBC.
Who is appearing for Public Service Commission?
I'm appearing for Public Service Commission. I'm seeking 1 week accommodation because no instruction is till yet.
Yes, yes.
My lord, there was only one candidate, that is the petitioner before lordship, who had qualified the practical test in OBC A category. That will be appearing from page 49 itself. Because lordship kindly sees serial
No,
number.
but there is no birth so far OBC A category is
No
concerned.
one has been recommended.
This is the final list.
Yes, this is a recommendation.
Recommendation list.
Yes. This cannot be possible, my lord. There were 2 posts reserved. And they are proceeding with the process. I'll be at this stage praying that 1 post may be kept vacant.
issue.
May I submit one thing, my lord, with regard to the recommendation is concerned, my lord, unless and until we are getting the eligible, suitable, absolute, suitable candidate, unless and until we get that suitable candidate,
How many posts were reserved for under OBC category?
two posts.
So why petitioner was not selected?
My lord, petitioner was not selected, that instruction is yet to be come to me.
Take instruction. Come back.
I'll be praying for my lord, the reservation of one post and my lord, the
And-
publication of marks.
At this stage, no interim order can be passed because I am seeking 1 week time.
Matter relates to filling up the post of instructor of trade of refrigeration. Now, trade of, yes, instructor in trade of refrigeration and AC mechanic in government industrial training institutes under administrative control of Directorate of Industrial Training and Industrial Training under the Technical Education, Training and Skill Development Department, Government of West Bengal. If it is technical education, why you are not moving group 2?
Service, group 6. Public
Sir,
service.
Lairi,
Public Service Commission.
It is
Recruitment
Yes,
process.
Public Service Commission.
Recruitment process.
Who appoints a teacher of Hindu school?
Traders.
Yes, who
Instruct-
appoints teacher in Hindu school, hair school, or Bethune Collegiate School? Mr. Lairi?
Not a college, not an education institution.
Yes, it's a other educational matter, education matters.
Physical education, training and skill development. Instructor.
Under technical education.
Education matter. Due to determination of the justice policy.
I should have taken this matter on merit first instead of considering the technical issue of maintainability.
Instructor. Instructor is not teacher. Instructor is not teacher, my lord.
Instructor in trade of refrigeration and AC mechanic in Government Industrial Training Institute. Training Institute. Teacher training course. Training Institute. It comes under higher education or other education because it is under a technical education.
Higher education.
বসো তো। Yes.
Your lordship determination of
Public service
government letter motion and hearing under Article 226 Constitution of India relating to service under group 6 and application collecting. 6 matter the service matter lordship. It lordship the any institute the here lordship I am.
That has been falling from the judge.
Huh?
I have nothing to say.
Far-reaching implications. Judgment will also.
Well, so far, my,
Not entertainable, nothing is entertainable.
That is what I am also thinking.
Didn't start.
so far, my knowledge goes that in school,
You have not taken this point. Court has taken this
Falling
point. Please take your seat.
falling
Enough is enough. You are praying for time to obtain instruction. Don't develop now, hearing this court.
already developed. Difficult.
Well, listen, since I have passed an order,
Yes. And they have not taken the point.
yes. হ্যাঁ কি বলছিলাম?
And
I have-
don't have a point.
প্রথমটাও যাও, প্রথমটা গ্রুপ 6 উনি শুনতে পারেন না।
Government instructor in trade of refrigeration and AC mechanic in Government Industrial Training Institute under administrative in Government Industrial Training Institute. Stop. It is submitted by the learned advocate. It is submitted by Mr. Lahiri, learned senior advocate representing the petitioner, that representing the petitioner, that he participated in the selection process as OBC A candidate, and in reference to a document dated 9 June 2025, which is at page 49 of the writ petition, it is submitted that petitioner's name featured at serial number 31 for participation in interview, which was scheduled on 24th June 2025. Stop. Next paragraph. On completion of selection process, a list of recommended candidate was notified via notification dated 25th September 2025, where name of the petitioner being OBC A category candidate did not feature. Stop. It is submitted that as no other candidate under OBC A category is recommended for appointment, petitioner is recommended for appointment, though there are vacancies under OBC A category. Petitioner was required to be included in the list of recommended candidate under OBC A category. Next paragraph. Learned advocate representing Public Service Commission has prayed for time to obtain instructions as to why name of the petitioner did not feature in the list of recommended candidates under OBC A category. Stop. Hearing of this matter stands adjourned. List the matter under the same heading on 28th January 2026. Stop. Next paragraph. If vacancy of instructor in trade of refrigeration and AC mechanic under OBC A category is available, in that event, one vacancy under the said
It is
category,
not in the prayer, Lordship.
one vacancy under the said category shall not be filled up till th January or till 13th February 2026 or until further order.
It is not in their prayer, Lordship.
The
Yeah,
answer
there
is
is-
to determination. I'll see the classification list also. It is group 2 relating to library, college, and university under group 2, including the service and applications connecting thereto and others. So this is and other educational matters which are not assigned. No. So therefore it is library, college, and this is not under university. This is under the Department of Technical Education and Training and Skill Development.
Okay.
So that is the
So it is saved.
safe.
That's why I have entertained. উপরে দিলে every service filed on behalf of the petition is taken on record.
Deep look. And let them produce the mark sheet also. Well,
Well, let them come and
all the selection process
আরে
now.
দাদা
they do
সবই
not
পেয়ে গেছে চলো
disclose the
সব পেয়ে
marks.
গেছে।
yes.
Item number 3.
The application I am disposing of. এসো তো 1 মিনিট আগের দিন ওটা ইয়ে হয়ে গেছে
It is also possible. No one is there.
দেখি ফাইলটা দাও on that issue there was no elaborate judgment regarding maintainability of this petition.
Not taken up. So that bridge we have already crossed.
That's why I have decided that because all are short orders by which the matters are entertained.
And we are very open. In any case, now the SAT is functional. Say for instance, after 1 or 2 weeks or 1 or 2 months, this judgment will be
Yes.
they will rely upon.
Application being can 1 of 2026 stands disposed of.
My lord, that judgment should be, my lord, referred for being reported because now there is only one journal, only CHN. Everything cannot go into.
CLJ is not.
No, CLJ is not there. This it's only coming out 4. It's previous used to be weekly when your lordships was there. CLJ was a very good journal. Finished
During COVID.
during COVID. Only one journal is surviving.
CH.
Therefore, there has to be some kind of, it's reportable, not reportable. It should be reportable. Deployed.
Item number 3.
Your Lordship, in item number 3, I'm appearing on behalf of the respondents.
Yes.
Lordships, I'm being led by Mr. Banerjee.
Banerjee.
On his, Mr. Rohit Banerjee. He's on his legs, Your Lordships. I'm humbly praying for a short passover.
The government for accommodation state farm. But the last occasion one Diksha Dhar.
Yes, Your Lordships.
But last occasion Rohit Banerjee did not appear.
No, Your Lordships. He's the arguing counsel.
Well, last you obtained you took time, not today.
Your
That is
Lordships,
exactly-
kindly.
On 6th January you took time.
Your Lordships,
you're saying.
kindly. Your
Not
Lordships
today.
may kindly grant us a short passover, Your Lordships. He's
No,
on his
it's
legs.
not possible. I do not because there are matters. Short passover is not possible. Either do the matter or not to do. Yes, next.
Item number 4.
Yes.
My lord, I'm extremely sorry for taking so much time, my lord, for doing this matter because I had to go through the entire guidelines that this SSC is following. My matter is not similar to the matter that my lord has already decided regarding a tattoo. But this matter is entirely res integra. My lord, kindly sees the DME and the RME, my lord, which is in page number. Affidavit of service. Page 56.
60.
56 is the RM. Lord, in the RM,
What is tattoo and superficial burn present?
and my lord,
Tattoo
superficial mark. There is no tattoo, my lord, anymore.
removal scar is there.
Yes, my lord.
Yes.
My lord.
When you have removed tattoo.
My lord, because it was instructed by the authorities that you remove the tattoo and apply
Yes.
apply for the
After DME, you remove the tattoo.
yes, my lord.
Is
It
a
was
tattoo
at the
right forearm?
of the authority.
Tattoo was on right forearm. It's a saluting arm.
Yes, my lord.
And in DME, at the time of DME, tattoo was there. At the
Yes, ma'am.
time of RME, tattoo was removed.
Tattoo was
I have
removed.
already decided the issue in another. Give
My
me the
lord.
judgment.
My lord, I am on the
Yes.
scar, my lord. My lord, kindly see.
Then the entered exercise of DME becomes Oshios. Sorry.
My lord, this judgment was per incuriam, my lord,
Yes.
because the division bench of Delhi High Court has already decided this matter, my lord. My lord, kindly considers Article 141, my lord, where there is a binding precedent, my lord. An honorable division bench has passed this.
That is not binding upon me.
My lord, it is not binding.
That is not
My
binding
lord,
upon me. It has got a persuasive value.
yes, my lord.
So
It
don't
has
make this
persuasive.
submission.
My lord, I am not.
Yes.
I am not on that point of binding nature. But my lord, I am only on the point of respecting a division bench judgment, my lord. My lord, may I kindly place my lord. My lord, paragraph number 11. If I may kindly read out.
Which judgment you are relying?
আমি দিয়ে দিচ্ছি কপি আপনাকে এই নিন। My lord, from paragraph number 11, if I may read out, is pertinent to
Wait.
The fact is something different, my lord.
My lord, it's absolutely the same. Right
In
for
page
of
12,
removal.
my lord, in page 12, paragraph 12.
হ্যাঁ কি হয়েছে রিমুভ করে এসছে
Different, madam. You argue before the court, why are you punching before me?
They are giving you the copy, right?
First of all, it is for a different post where this revised guidelines of 2015 is not applicable. It is for Delhi police constable male in Delhi police 2023.
Hello, they had the same
Second,
guideline.
prior to this review medical board detailed medical examination or the first medical examination on 20th January 2024. Even before said period, respondent was undergoing the surgery.
Undergoing the
So
surgery after the DA.
here it is not it is not the case. In the present case, petitioner had tattoo while participating in or while he was tested by detailed medical board, and subsequently he removed the tattoo and appeared in the review medical board. That conduct is not permissible, I have
My
said.
lord,
So therefore, this judgment is not applicable so far the present case is concerned.
my lord,
And the issue was considered on the anvil of revised medical guidelines of May 2015. Is it a case that in case of appointment of constable under Delhi Police Delhi Police so far 2023 selection process, that revised guidelines of 2015 is applicable?
my lord, not revised guidelines, but they had a similar guideline where it says
Where
that
is my
platform,
judgment?
the right forum
Mr.
is not.
Chakra?
My lord, and
I've given-
my lord, may I rely on another Supreme Court judgment, my lord, where it says, my
The
lord,
only point
Ek
is,
minute, dear.
my learned friend is relying on a judgment where the fact is absolutely different, and that is in paragraph 12. madam.
Yes, yes.
Once,
Paragraph 12 says, in reference to paragraph 12, I have said that in the present scale, medical board was held on 20th January 2024, and subsequently the review medical board was held on 22nd January 2024. Even before said period, the respondent was undergoing surgery. That is before the preliminary medical board, this surgery was done.
fact is different.
But it is here after participating in DME, petitioner removed tattoo.
My lord, if I may rely on the guidelines
that
that,
is
they
a
are providing,
valid
my lord.
judge.
My lord, the guidelines that they have provided, my lord, where it says that the RME, the review
Yes, sir.
medical examination, will be conducted in continuation of the detailed medical examination. My lord, kindly considers, my lord. My lord, kindly gives me, bears with me for some time, my lord. If I may rely on the guidelines that they are relying on. My lord, in the RME, my lord, can I just read out the guidelines, my lord?
So before making submission that my judgment is par incuriam, you should apply your mind.
My lord, in that judgment also, my lord,
You should apply your mind.
my lord, they are not
Yes,
relying
yes.
on 2015 guideline, but my lord, they are relying on the same medical standard of constable. Lord, it is this, they have the same guidelines.
There may be different views by different courts. But before making such a bold submission before this court that, my lord, your judgment is par incuriam, you should apply your mind.
Lord,
Whether
they
this
had the
judgment,
same
my
guideline,
judgment
my
can be
lord.
termed as par incuriam or not.
My lord,
Is
they
it
had
if
the
I
same
remember
guideline, my
well,
lord.
the last occasion they say the judgment was
Yes.
right before a division. They said it before this.
My lord, the recruitment authority is SSC, my lord. My lord, I am relying on this judgment only because the recruitment authority is SSC and they are on the same guideline that a tattoo on the right forearm is not allowed, my lord. My lord, and also the guidelines for RME is also given where it has to be conducted by experts, my lord. My lord, whether the doctors are dermatologists or experts, that has to be checked, my lord, that who have given it, so who have given passed the report in RME.
Have you disclosed that when you removed tattoo?
Yes, my lord. I have disclosed that.
In which paragraph?
So it is in page number 54, where I have annexed the copy of the surgery that I have undergone. Paragraph
54.
on page 54 and 55.
Have you stated in the writ petition?
But I will,
Where you have stated? In which paragraph?
yeah, check this out. Paragraph number 8, my lord. Page number 5, paragraph number 8. Relying on the assurance given by the authority on 30th November, he visited this center to undergo tattoo removal, and upon filling up the form, the petitioner was asked to go for a procedure on 1st of December.
The assurance is written above, that is not sure also.
My lord,
Not- not-
my lord,
it is
the only ground for rejection in
Because
DME
I
is
am-
tattoo removal.
I am bound by my own decision. How I can deviate?
My lord, larger bench, my lord.
How I can deviate? Tell me. I have
My
on a
lord,
similar.
My lord was not as
on a
rightly
similar
assisted, my lord.
situation on an identical issue unless until my judgment is set aside by the honorable division bench. I have to follow my own decision. That was Mr. Kundu appeared in that matter.
My lord, that is the
He speaks
exception
whether
to,
he has preferred appeal or not.
my lord, yes, my lord, he has.
Uh.
My lord,
So therefore, I am bound by my own
no,
decision.
my lord.
Issue.
My lord, that is the exception to the doctrine of
Matter
stare
is to
decisis, my lord. My lord, may I refer to another Supreme Court judgment, my lord?
affidavit of service filed. Affidavit of service
My lord,
filed.
kindly.
On
And one more
petitioner
thing, my lord,
taken
let
on
the file
record.
report as to the experts
Stop.
who have examined him medically as per
Petitioner taken-
guidelines, my lord.
Yes, Supreme Court judgment. What is the ratio?
My lord, in the Supreme Court judgment, it is clearly stated, my lord, that it is true that the petitioner was examined twice over and was found to be medically unfit. However, considering the nature of the ailment and medical condition, the issue appears to be remediable and not of any permanent character. My lord, he has already
But that
remedied.
is here the
My
fact
lord,
is
and-
completely different.
My lord, the RME is a continuation of DME. My lord,
So they can.
he shouldn't be allowed to appear for the RME because the only ground for rejection in DME was tattoo removal. Then why would he be allowed to review his examination, my lord? My lord, what is the purpose of RME? I asked this question to myself, my lord. My lord, everybody deserves a second chance, my lord.
There's a direction to constitute medical board and return a finding. How that this will apply in this
My
matter?
lord, because the tattoo is a curable
What
and
Supreme Court
remediable defect,
directed?
my lord.
Supreme Court directed to constitute a medical board on DNS, that is deviated nasal septum,
My lord,
and
that is a
return
different
a
defect.
finding.
Yes, my lord.
So therefore, why you are relying upon
My
this
lord, I am
order?
relying because it is remediable, and that's why even after
So before
RME,
before placing this judgment of the Honorable Supreme Court, you should apply your mind that whether it is applicable in this case or not.
my lord, tattoo is remediable and it has already been remedied, my lord.
You are not answering my query.
Yes, my lord, this judgment.
You are
is
not
on
answering
different
my
point.
query. Supreme Court has not said that he is to be appointed. And it is
My
not
lord,
an
I am also
issue
not saying he
that
has to be appointed,
you
my
have deliberately changed the situation after participating in detailed medical
lord. My
examination.
lord, I am also not saying that he has to
Issue.
be appointed, my lord. Kindly
And
gives
that
him
will
another
happen within
chance,
3
my lord.
days. Any other point?
Yes, my lord. Yes, my lord. My lord, in the guidelines that they are relying on, in the guidelines it is stated that review medical board may obtain opinion of concerned specialist or super specialist of government medical college and hospital in case of any doubt. Therefore, in case of rejection in the review medical examination, clinical findings should be corroborated with conformity test or investigation or opinion of the specialist or super specialist of government hospital or medical college or government approved.
Any other point? Any other
My
issue?
lord, and on the point of scars, my lord, like presently after the RME, they are only on the point of scars that has occurred due to removal of tattoo. But on the point
It
of
is not a point of scar. You participated in detailed medical examination with tattoo.
yes, my lord.
So
I have-
therefore, matter ends there.
my lord, matter does not end there,
Subsequently,
my
in
lord.
order to, in
RME is a
pursuit of
continuation.
getting a declaration of fit certificate or getting a fit certificate, you remove tattoo.
My lord, with
What
the
prevented you to remove tattoo prior to participation in
my lord,
DNS,
he is
in detailed
my
medical
lord, he is not a
examination?
graduate, my lord. He is not even aware that tattoo is not allowed. Lord, it is just written. It was just written, ma, my lord.
Please don't
It is just
discuss this
the
course. Please take
my
your
lord.
seat.
May I
Yes,
kindly-
enough is enough. Please take your seat.
My lord,
I have
may
heard
kindly
you.
refer to
Yes,
the scars
yes,
point,
yes.
my lord.
Please take your seat. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Matter is heard extensively in presence of the learned advocates representing the petitioner and Union of India. Stop. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within bracket CAPFS. Stop. In connection with the said selection process, petitioner appeared before detailed medical examination on 4th November for detailed medical examination
29th of November.
On 29th of November.
on 29th November 2025, and he was declared unfit since on right forearm of the petitioner presence of tattoo was found. Stop. Petition next stop. Petitioner remove tattoo
On 1st of December.
Yes, yes. Petitioner removed tattoo on undergoing a therapy on 1st December 2025 and thereafter participated in review medical examination on 4th December 2025. Stop. In review medical examination, medical experts opined
No, they are not expert.
that the petitioner was not fit as tattoo and superficial burn scar was found to be present on right forearm of the petitioner. Stop. Questioning. A review medical report dated 4th December 2025, writ petition is filed with a direction upon the concerned respondent authorities to appoint the petitioner as Constable GD under CAPF Act. In support of contentions raised in this petition, reliance is placed on the judgment of on an order of the Honorable Supreme Court dated 19 July 2019, passed on writ petition within bracket S close bracket within bracket civil close bracket number within bracket S close bracket 444/2019 within bracket Dharmveer Singh versus the state of Uttar Pradesh and others, and an order of the Division Bench of Delhi High Court reported in 2024 SCC Online Delhi 5162 within bracket Staff Selection Commission and others versus Deepak Jadhav. Next paragraph. Learned advocate representing Union of India has opposed this writ petition and has placed reliance on the judgment of this court dated 2/1/2026, passed on a writ petition being WPA 28705 of 2025 within bracket Rahul Bari versus Union of India and others. Close bracket. Stop. In addition thereto, it is also submitted that admittedly petitioner had tattoo on the date of his participation in detailed medical examination. Therefore, situation should not. Therefore, by subsequent removal of tattoo, situation ought not to be improved, thereby declaring the petitioner fit on his participation in review medical examination, which was conducted on
4th of December.
4th December 2025. Next paragraph. In Deepak Jadhav Supra, Division Bench of Delhi High Court was considering selection in the post of constable in Delhi Police for the year 2023. Where revised medical guidelines to puro namta diye debe to of May 2025 is not applicable. Stop. Moreover, from paragraph 12 it appears first medical board was held on 28th January 2024 and review medical board was held on 22nd January 2024, and the candidate prior thereto and candidate prior to his participation in first medical board by undergoing surgery removed tattoo.
His tattoo was found faded
Stop.
on the right forearm.
It is also recorded in paragraph 13 that the honorable division that the division bench physically saw the candidate physically saw the right forearm of the candidate who was present in court, and it was found that tattoo was not visible. Stop. Here in the present case, different set of guidelines of May 2015, different set of revised guidelines of May 2015 are applicable for appointment in the post of constable GD under CAPFS. Stop. Stop the corona. And fact is, petitioner participated in detailed medical examination with tattoo and thereafter removed tattoo prior to appearing before the medical experts in review medical examination. Stop. Therefore, the facts of the case is not akin to the facts. Facts of the present case are not akin to the facts which were considered by the division bench in Deepak Jadhav Supra. Stop. Order of the Honorable Supreme Court dated 19 July 2019 in Dharamveer Singh Supra does not come in aid of the petitioner, wherein Honorable Supreme Court directed to constitute a medical board comprising medical professionals for examining the candidate in order to furnish a report as the candidate was diagnosed with deviated nasal septum within bracket DNS. Next paragraph. In identical situation, while deciding the writ petition being WPA 28705 of 2025, court delivered judgment on 2nd January 2026. Paragraph 7, 8, and 9 of the said judgment is paragraph 7, 8, and 9 runs infra. এটাকে set out করে দেবো। Next paragraph. Facts which were prevalent, facts which were considered in Rahul Bari Supra is similar to the facts involved in this writ petition, as the petitioner, in pursuit of being declared fit in review medical examination, removed tattoo on 1st December 2025 after participating in detailed medical examination, which was conducted on 29 November 2025, and before participation in review medical examination held on 4 December 2025, and same is not countenanced. Hence, writ petition stands dismissed.
My lord, kindly records the guidelines, my lord, where the RME was not conducted by the
Next matter.
experts.
না, consciously include.
Item number 5.
J2 ফর্মে করে দিন।
Union of India has also been served with the copy, madam. The petitioner is the development officer of the Life Insurance Corporation of India, my lord. And my lord, a show cause notice was issued to the petitioner, my lord, explaining to my lord about his performance, my lord, and whether he should be able to, my lord, maintain the cost issue. But I've prayed for a stay of the, my lord, the show cause notice, my lord, subject to, my lord, the proceedings should continue, my lord, but no final order will be passed, my lord, in view of, my lord, the SLP pending, my lord, before this honorable court.
What has happened to that matter?
Yesterday it was taken up, my lord. It was not finished, my lord. It was in the cause list. 27th is the next date. And my lord, one more thing, my lord. Kindly sees the office report. The LIC is yet to file, my lord, any affidavit in the SLP. That is the office report.
I have passed a similar order.
Yes, yes, yes.
Where is that order? Do you have the copy?
My lord, my learned friend has annexed it, but however, he may.
Some corrections, my lord.
That application has to be hard.
Yes, my lord, that is appearing in my lord's list.
It was taken out after
Yes,
vacation.
yes, yes, yes.
Let me see. In the meantime, if the final verdict come from the Supreme Court, then
It's
the task of this court would be easier. Matter is hard on the
otherwise also, my lord, we are very hopeful to an extent our application is.
Yes.
It is Supreme Court is later.
Thank you.
What is the date of show cause notice?
20th of November.
Page.
Page where it is 46.
Then this 20th January 2026 is already over. So far the special leave petition is concerned. It is running in the list.
Yesterday, my lord, it ran in the list, my lord, did not be taken up, could not be taken up. That's why, my lord, the next date automatically falls, my lord, that is on 27th.
এই একটা লাইন অ্যাড করে দাও এখানে। Honorable Supreme Court is in ceasing of aforesaid special leave petition. এইখানে এটা অ্যাড করে দেবো। I am fixing it in the month of April 2026.
My lord.
That liberty is already
Yes.
there. If the situation is altered
Situation arise,
in view by virtue of the order to be passed by the Honorable Supreme Court, make an application and appropriate orders to be passed.
or if my lord decides
Yes,
otherwise in those
yes.
absences.
এটা দেখে করে দেবে।
Great, my lord.
অর্পণ very matter table.
Item number 6.
Why? Who is appearing? Not today. No, I pass over, I don't have.
Tomorrow I have difficulty. If Malad kindly fixes on.
No.
Malad,
Come back. No. Sorry, not today.
Malad, tomorrow I won't be here, Malad. That is the difficulty.
No, please come tomorrow. Yes, next matter.
Malad, part of this matter is not maintainable also, my lord.
Next matter.
Item number 7.
Malad, tomorrow again I have to seek adjournment.
Next.
Lordship, I appear for Union of India. I am being led by Mr. Ramchandra Agarwal.
Yes.
PRPF rejection process, after being qualified the written examination, PST, and physical test also. At the time of medical, I was declared unfit.
What is the reason?
Reason,
What is the medical reason behind declaring the petitioner unfit?
on finger is effective. That is the
What is written at page 16? DME?
16.
Yes. This is a DME report. This is detailed medical examination report. Page 16. What is written? Tell me. Reading it fast. That is the first hurdle. Yes.
Deformity of install
Bilateral deformity of
bands
Balance of index finger.
of index finger.
Yes.
yes. Read it in its entirety. Bilateral deformity of
Distal.
distal phalanx. Distal phalanx of
Index finger.
Index finger.
Index finger.
This is the fourth.
Is a separate finger comes out of the.
No, only the finger is some increasement, muscle movement. That is
Deformity, bony bony, come to page 17, bony deformity, this state. Bony deformity, so the deformation in bones. Yes, is there whether such deformity is one of the grounds to declare a candidate unfit in terms of revised medical guidelines? Show me.
I suppose, but I will have to seek some instruction on it.
Issue. Affidavit service.
I have treated in the government medical hospital.
Affidavit service. Yes.
There,
Yes.
they have said, Your Lordship, kindly see the
Page 18.
18, 19, 20, these are the reports. And tests were conducted, and 21 is the ultimate
Distal phalanx.
patient is fit for regular duty and
But your report does not say that you are fit. Come to page 20. It supports the view expressed by the medical experts. Impression shorter distal phalanx of both the index finger. Clinical correction suggested. Yes, what my lord? Then it shows that there is a deformity for which clinical correction is required.
But this deformity, whether this can debar the candidate, that has to be assessed.
That you show me from the detailed medical examination from the revised medical guidelines of May 2015. This is your writ petition. You have to make out your case. Yes. Why tomorrow? You know that before this court, as per presentation form matter comes, you should be made ready. You should make yourself ready. There is deformity. Your X-ray report suggests shorter distal phalanges of both the index finger. Clinical correction suggested.
This deformity is not.
There are matters which are coming that the private medical institution or the hospitals are saying that no, candidate is fit. That I can understand, but here already deformity is corroborated as it appears from document at page 20 and clinical correlation suggested.
Deformity, only bony deformity.
Okay. Debarring probation is bony deformity of elbow. This is the debarment.
Tommy, give me a copy. It's a thick, voluminous guidelines.
Yes, yes.
It is voluminous guidelines.
Because page 21 says his feet for his regular duty. Though there is deformities, but these deformities, it has been ascertained, page 21, that he is fit for regular duty.
Issue. So when court is about to pass an order, better not to place other matters, other documents, which may be counterproductive.
Stop there.
You have shown me a document which supports the case of the respondent.
Not supporting.
Yes, yes.
Deformity.
Shorter distal phalanges. This is
Deformity
correct.
is
Now you have to point it out why this deformity should be ignored.
I have to print it out and come.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within bracket CAPFS. Stop. Petitioner qualified in written test and in physical standard test. Stop. However, in review medical examination, petitioner was declared unfit for the reasons stated there. Next paragraph, Union of India is represented by learned advocates. Next paragraph. Concerned respondent authority is directed to file a report disclosing as to why petitioner was declared unfit based on revised medical guidelines of May 2015. Stop. Next, let such a report be filed by fortnight from date. Stop. List the matter under the same heading for further consideration on. On 26th February 2026. Next.
My lord, on the last matter, my lord, the petitioner's advocate is present, my lord. I am for the respondent.
Sorry, next matter.
Item number 8.
The petitioner applied for the post of the constable JD in the CAPF. My lord, kindly comes to page where she was rejected on the of psychological disorder. My lord, kindly comes to page number 22. Page 22, where the detailed medical examination was carried out. My lord will see. Page number 22, my lord.
Yes, tell me what is the disorder?
My lord, because of her multiple scar mark on the left forearm, he was declared as psychologically unfit. My lord, kindly comes to page number 21, where the review medical examination was done. Paragraph 3.
Why scar marks are there on left forearm?
These are normal scar marks, my lord. She has
No, scar does not. Scars do not generate normally.
My lord, since she is participating in the sports activity, various sports activity, and she has met with the minor accident during her childhood age. My lord will kindly appreciate that in this page number 22, she has got a scar mark on her chin also.
That is different thing.
That is
But on forearm, why there is scar mark?
That is because of the
Scar mark is not an. It has been inflicted by the petitioner herself.
No, my lord.
Or himself.
No, my lord. What has happened, my lord? The petitioner, being a Bengali, and she was asked in the what the petitioner has expressed before me, that she was asked in the Hindi language that ये आपके साथ मतलब आपका एक्सीडेंट हुआ था, क्या हुआ था, या ये आपके ऊपर कोई assault एक्सीडेंट हुआ, आपके ऊपर कोई assault हुआ था, अटैक हुआ था, या खुद से हुआ था. She could not. She said, "I was not a subject to any accident, and as such."
Then why is karma?
Because that is my respectful submission, Your Honor, is that she is actively participating in sports activities. She belongs to a rural background. So that's why while playing in the child, and she has sustained minor injury also. It is never self-inflicted. My lord will kindly appreciate, based on my, and it is in the left forearm, not in the saluting hand. My lord will kindly appreciate that based on my scar mark, can I be declared psychologically unfit? My lord, I'm only to the point, my lord.
A normal person doesn't have any scar mark. Do you have any scar mark on your left forearm?
I do not have a.
Do I have any scar mark on my left forearm?
I have, unfortunately, because of
multiple.
It is not multiple. That is why, my lord.
It is stated therein. Ask your junior whether she has scar mark on her left forearm.
My lord will.
Maybe one, but not multiple.
It is not multiple, my lord. These are the scar marks which she has sustained during this.
File a report.
My lord.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within bracket CAPFS stock. Petitioner qualified in written test and physical standard test. Next paragraph. However, in review medical examination, petitioner was declared unfit on certain grounds as delineated therein. Next paragraph. Union of India is represented by learned advocates. Next paragraph. The concerned respondent authority is directed to file a report in the form of affidavit disclosing as to why petitioner was declared unfit based on revised medical guidelines of May 2015. Stop. Next paragraph. Let such report be filed by fortnight from date. Stop.
Milord, praying for more. Milord, I have instruction that all of the officers, including IG, have been deployed in the borders, Milord. And so, Milord, they will come back on 29th, Milord.
Yes, yes. By fortnight from date. Stop. Next paragraph. List the matter under the same heading for further consideration on 26th February 2020.
My lord, may I be sir? My lord,
One
let
more
my
time, Milord.
my lord, let
Sorry.
my candidature be protected because ultimately my petition
No,
will
sorry.
become infructuous.
No.
স্যার আমি আপনাকে কিছু বলতে চাই একটু যদি অনুমতি করেন
এটা তো মেনশনিং এর সময় নয় আপনাকে সকালবেলা এসে 10:30টার
I
সময়
don't know the what procedure to adopt in this regard.
এটা মেনশনিং এর সময় নয়
10:30টায় সকালবেলা।
উকিল বাবুরা বয়স্ক লোক সবাই সকালবেলা করেন
আমি মালদা থেকে আসছি
আপনি
বুড়ো
কালকে
বয়স,
করুন
76 বছর
আজকে
বয়স
এটা
আমার।
মেনশনিং এর সময় নয় আমি এই সময় মেনশনিং অ্যালাউ করি না
কিন্তু আমি
Yes.
Item number 9.
9, may I please, Your Lordship, I am for the petition. This is my
For the
affidavit of
respondent.
service. Here, my candidature has been rejected on the ground of deviated nasal septum. Well, the review, detailed medical examination board order is page 20. And page 21 is the review medical examination board order. Well, I have checked, and the guideline says the mild and moderate is acceptable. Page 22 is the Calcutta National Medical College and Hospital gives this document. Patient is able to breathe equally well from both sides of the nose. Medically fit. And your lordships also on the similar ground referred this petitioner to before the Kullani
Sure.
for
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within bracket CAPFS. Stop. Petitioner qualified in written examination and physical standard test. Stop. Petitioner was declared
physical efficiency test also.
PST standard test
and PET.
Physical standard test. Stop. Petitioner was declared unfit in review medical examination. Stop.
A date may be provided to file
What
report.
petitioner was declared unfit in review medical examination as petitioner was diagnosed with deviated nasal septum within bracket DNS. Next paragraph. Respondents are represented by learned advocate. Next paragraph. Learned advocate representing union of concerned respondent authority. Union of India is represented by learned advocate. Stop. Next paragraph. Concerned respondent authority is directed to file a report disclosing as to why petitioner was declared unfit based on based on revised medical guidelines of May 2015. Stop. Next paragraph. Let such report be filed by fortnight from date. Stop. List the matter under the same heading for further consideration on 26th February 20.
In the meantime, my lord, kindly protect me. Otherwise, my lord, my lord, candidates are
Sorry.
Item number 10.
Because your candidature cannot be your right to be considered cannot be affected because it is a selection process where I have heard a matter where it is specifically stated that against a particular number of posts, similar number of candidates are selected. It is not a selection process where the list of selected candidates is more than the number of vacancies. If that is so, ultimately, if you are found to be eligible to be appointed, then posts will be there because they are following a norms. They are following a norms that suppose there are 1500 posts.
Yes.
Again, 1500 posts, 1500 names are published by publishing final result. And that has been published on 15th of January, probably.
15th of January, and all over India basis, 3,200 posts are unfilled.
Now, if any posts remaining unfilled,
yes,
then that will be carried forward to the next selection. That is selection. That is selection process of 2026.
And 2020.
So therefore,
if
a procedure is if it is a procedure that against 1500 posts, say 2000 names are included in the panel, then you may have a difficulty of getting birth on being if the writ petition is ultimately allowed. But that situation is not there with regard to selection process for constable under CAPFS.
And moreover, the honorable division bench judgment also there. My lord, if I found fit, then the authorities create a superannuary post and
Yes.
Next. Item number 10.
in my lord, I am for the petitioner. This is my affidavit of service here. My candidature has been rejected on the ground of flat foot, right flat foot.
That is one of the grounds under the.
Yes, but that rider is there. There are the provisions how the flat foot is to be calculated and which type of flat foot. My flat foot is acceptable. In a minor acceptable is also there. If you losses have a look on the minor acceptability point also there, and the flat foot clause also said that my flat foot.
Yes.
The flat foot, my lord, so I am.
File a report. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within bracket CAPFS. Close bracket. Petitioner qualified in written test and physical standard test. Stop. However, in review medical examination, petitioner was declared unfit on the ground of right flat foot, FOOT, right flat foot. Stop. Next paragraph, Union of India is represented by learned advocate. Stop. Concerned respondent authority is directed to file a report in the form of affidavit. Now, is directed to file a report by 3 weeks from date. Stop. Now, concerned respondent authorities is directed to file a report. File a report disclosing as to why petitioner was declared unfit based on revised medical guidelines of May 2015. Next paragraph. Let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on. February 2026.
What's up?
Take it. It is whose document?
My
Take it.
document.
Item number 11.
11, my lord, I am for the petitioner. This is my affidavit of service. Here, my candidature has been rejected. Kindly come to page 23.
Multiple
hesitation.
What hesitation?
On left, cut
What is
mark on
hesitation
left.
mark?
Hesitation marks is cut mark.
Cut marks.
Hesitation cut mark on the left forearm. And the page 25 is also said that multiple hesitation mark on left forearm. Look, this is not the ground so that the authority can reject it.
Declare a candidate unfit.
That they
Hesitation cut marks on left forearm.
left forearm.
If-
Medical guideline does not say so.
Lordship, if
Why cut marks on left forearm?
The person is belong to the village area.
What?
Sometimes he climb the coconut tree, sleep, kid, and this cut marks comes.
You don't have any relatives or friends who stay in rural areas?
My lord, I have.
Have you come across?
Myself, I am.
Have you come across
So
that
I
those
have that
those
experience
rural
also.
persons have cut marks on forearm?
My lord,
I don't find anybody.
my lord,
I have lot of
both the cut marks.
I have acquaintance with lot of persons who
Once
stay in rural areas, but I haven't found
I
that
have,
those persons are having cut marks on forearms.
my lord, I have both.
So
the,
therefore, I am not accepting this explanation.
that is the different issue. But this is medical guideline does not say so that if the person has the hesitation marks of any of the arm, my lord, he should be debarred from the and I'm declared unfit for the in the medical examination. That is all of my submission. In this guideline, I have pointed out every sentence and in every words. Nowhere I can find.
There are many known persons, so far I am concerned, they stay in rural areas, but they don't have cut marks on the forearms.
My practical knowledge from memory, it is not in the in this matter. I have the cut marks from the for climbing of coconut tree, and I skid.
Multiple.
Yes, there's multiple. So many cut marks was there, but that has been removed. One ointment is there, that has been removed.
Yes.
In chest also, everything was mashed. This is the difficulty. I don't know from where they get, but in this medical guideline, nowhere it has been mentioned that the having multiple cut marks on the arm, the candidature can be rejected medically on medical grounds.
Lordship, in page,
That is the thing.
in page number 25, it is written, as per psychiatrist's opinion, these are impulsive, self-inflicted.
Page number 25.
25, Lordship. Self-inflicted.
Where? As per yes, as per
In brief,
psychiatry opinion, these are impulsive, self-inflicted marks on left forearms.
Yes. Kindly have a look, page 26. Page 26.
And the administration would be in difficulty after including the petitioner as a part of discipline
That will
force.
not done. That will not
And
done.
this
because-
self-infliction will continue.
That will not done because
Then there will be initiation of disciplinary proceedings.
without
A lot of
psychometric test,
difficulties are there.
without psychometric test, they cannot say. Kindly come to page 26 of my writ application.
Whenever cases are coming before me, issues are that multiple cut marks on
Hesitation
forearms.
of cut
Yes, petitioner resides at rural areas. Petitioner belongs to a particular community. But we do not find that any persons staying in rural areas having cut marks on forearms.
Page 26, kindly have a look. I have checked that on the on very next, 8 December 2025, before the Balurghat Medical Super Specialty Medical College in the psychiatrist department. They refer me in the Science College Rajabajar for psychometric test. After psychometric test, getting the psychometric test, page 27. They have found my IQ level and abnormality. There is no abnormality. Kindly have a look, page 28, the relevant portion. That's why I have done this.
You should be cautious while interacting with the petitioner.
That's right. Asking for material instruction, you can be. Page 28, the
file a report
also says so.
Affidavit to service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within bracket CAPFS and qualified in written examination and physical standard test. Stop. However, in review medical examination, petitioner was declared unfit on the ground of hesitation cut marks on left forearm. Stop. Next paragraph. Union of India is represented by learned advocates. Stop. Next paragraph. Concerned respondent authority is directed to file a report in the form of file a report declaring as to why petitioner was declared unfit based on a review based on revised medical guidelines of May 2015. Next paragraph. Let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on 25th February 2026. Next.
Item number 12.
12, may I please, Lordship? This is my affidavit of service. Here my candidature has been rejected by the detailed medical examination board, page 24. my low distance vision, 6/12, 6/9. The next page, page 25.
And then another burn marks,
That I have
forearm.
that I have passed. I have passed. They have passed me in that case. Only the ground has been left. That is in review medical examination, page 25.
Nothing is readable
Well,
under under unfit reasons for declaring unfit.
defective distance vision normal 6/6, 6/9. Here, down, in the left side down, bottom of the page, the has been indicated 6/9, 6/9. Both the eye. My left eye is the within
6/6.
Left.
This was measured in review medical examination and detailed 6/12, 6/9.
6/9. My lord, 6/9 is my left eye. That is within the permissible limit. 6/9 they have found in DME 6/12. Here they have found me 6/9. My lord, the page 26. I have checked myself in Medinipur Medical College. They have measured me 6/6, 6/6. Thereafter, again I go for any private doctor. Again I go for any government hospital. They have also measured me 6/6, 6/6. Both the eyes.
If it is more than 6/6, that is 6/9 or 6/12, then it is low vision.
No, 6/9 is acceptable in rose eye. If I am right-hander, my left eye is 6/9 is permissible. And if I left-hander, then my right eye is 6/9 is permissible. That's why I am review medical examination board's report 6/9 is left eye is permissible, but only one ground is left, that is 6/9 in my right eye. That I clarified in 3 specialist doctors who says and measuring me 6/6, 6/6, all of 3 hospitals, 3 places. That's why
What is stated defective?
Distance vision. Review medical examination board in unfit ground of unfit defective distance vision. And within bracket normal they have mentioned 6/6 and 6/9.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as constable GD under Central Armed Police Forces within bracket CAPFS. Stop. Close bracket. Petitioner qualified in written test and physical standard test, but in review medical examination, petitioner was declared unfit on the ground of defective distant vision. Defective distant vision. Stop. Petitioner, next paragraph. This Union of India is represented by learned advocate. Stop. Next paragraph. Concerned respondent authority is directed to file a report disclosing as to why petitioner was declared unfit based on revised medical guidelines of May 2015. Next paragraph. Let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on 25th February 2026. Next.
Item number 13.
13, may I please, Lordship, this is my affidavit of service. Here, my candidature has been rejected, page 19. 2 ground has been assigned by the detailed medical examination board.
Why these matters are filed after publication of final list?
No, it is prior to publication.
Publication of final result.
This is prior to publication of results. Only 3 or 4 matter files after 15. My lord, the delay has been rejected, explained, and moreover, they have not published the merit list. Only selected.
So it was filed on 3rd January.
Yes.
And final list, final result 15 January.
15 January at 9 p.m. My lord, here page 19.
Valgus.
Cubitus,
Cubitus, valgus.
deformity are external hemorrhoid. 2 grounds. The review medical examination board also affirm that findings of the DME board. Here also bilateral cubitus valgus, deformity and external hemorrhoids at 10 o'clock position.
What is stated in review medical examination?
Here
Unfit due
to bilateral cubitus valgus and deformities and external
hemorrhoids.
at 10 o'clock position. My lord, I thereafter, my lord, page 21, NRS Medical Hospital certified that I have the angle within the permissible limit, 18.3 degree left, right, and 19.2 degree is left. That is the within the permissible limit. And hemorrhoids, in case I went to the Kollani Ames, page 23, it has been specifically mentioned that there is no such swelling or any other. And moreover, hemorrhoids are 4 grades. Grade 1 is permissible. My hemorrhoids is like piles.
Yes, no.
And it's 4 grades. Grade 1 is permissible. Well, at page 23, I went to the Kollani Ames for checking myself. The doctor of Kollani Ames says no enlarged anal. The hypothesis is 4 o'clock is like grade 1. Well, at here the medical guideline.
But
also,
both the reasons which were found in detailed medical examination were also found in review medical examination.
both the affirm.
And individually, both deformities are the reasons for declaring a candidate unfit.
Yes, but
if it is a case of hemorrhoids, it's a deformity or it's a defect for which candidate needs to be declared unfit. If it is cubitus valgus, in that event also it's a valid deformity.
Yes, but
It's a deformity which is to be considered as a valid ground for declaring a candidate unfit.
But hemorrhoids is 4 grade. It has been specifically mentioned in guideline. That is the kindly have a look. Hemorrhoids without bleeding.
Deformity present.
That is acceptable. Hemorrhoid with evidence of bleeding is disqualification. And carrying angle up to 20 degree is acceptable. I have 18 degree and 19 degree in both my hands.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within bracket CAPFS. Next. Stop. Petitioner qualified in written test and physical standard test, but in review medical examination, petitioner was declared unfit on account of cubitus valgus, দেখে নেবে পেজ 20 তে আছে, and external hemorrhoids. Stop. Next paragraph. Union of India is represented by learned advocates. Next paragraph. Concerned respondent authority is directed to file a report in the form of disclosing as to why petitioner was declared unfit based on revised medical guidelines of May 2015. Stop. Next paragraph. Let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on 25th February 2026. Next.
Item number 14.
14, may I please, Your Lordship, I am for the. The female candidate, here my candidature has been rejected, page 22 in detailed medical examination on Cubitus valgus.
That is a kind of carrying angle.
Carrying angle. Cubitus valgus is carrying angle. Carrying angle. So the medical term is carrying cubitus, the deformity is carrying angle. But here in review medical examination, again measure 21 and 22 degree with the female candidate within the acceptable limit.
The angle is given right 21 degree, left 22 degree, where the permissible angle is up to 15 degrees.
Up to 15 degrees in case of male 20 and female 25. If there is no bony deformity or accidental deformity or any abnormality in elbow joint. Well, that has been specifically mentioned in the medical guideline itself. And moreover, my lord, my carrying angle is not more than 20 degree. It's 14 degree and 15 degree.
Permissible carrying.
I have challenged the measurement of the their measurement.
Yes, no, there is
not properly measured.
There is an endorsement as per CAPF medical recruitment manual. Medical recruitment manual.
Yes.
The maximum permissible carrying angle for female is 20 degree, and anything above is
a case of rejection.
Is case of rejection.
Carrying angle. Yes. I am showing the guideline. Carrying angle normally.
Where is the defect in the review medical report?
They have not properly measured. My measurement is there, my lord, page 24. Baharampur Government Medical College. It is not a disease, it is a deformity. My lord, carrying angle measured 14 degree and 15 degree.
Show me from the medical guidelines.
Yes, medical guideline. First, my lord, kindly look on the minor acceptance, clause 7.
Is not required. For female, what is the permissible limit that is required? Show me that in case of my female candidate, carrying an angle up to 25 degrees permissible, as you have submitted just now. Yes.
Page 18. The bottom portion, it has been written, the page ignition. Page 18, carrying angle.
This angle is normally.
May I read for the lordship? The carrying angle.
And in females, 15 to 20 degrees.
15 to 20 degrees normal.
Yes.
Normal limit.
Yes.
And the next slide, kindly have a look. Next slide. However, candidates have carrying angle up to 20 degrees. That is the male. But if the male candidate
up to 20 may be accepted if the same is not associated with abnormality of elbow joint.
Elbow joint.
Not in your case, it was 21 degree and 22 degrees.
They have measured.
Yes. Court will not measure it.
No.
Court doesn't know how to measure it.
Your lordship's measure or I measure. My lord, I am saying that the government medical college, Murshidabad Medical College,
Esho.
measured that my angle is 50, 14 and 15. And in case of female, it should be 25. My lord, they have declared fit in 25 degree, having 25 degree heading. In some other case. Then the review medical examination board also indicates that my elbow joint is deformity, elbow joint is abnormal. It is specifically mentioned.
Affidavit of service filed on behalf of the petitioner is taken on record. Stop.
However,
petitioner matter is heard in presence of the learned advocates representing the petitioner and Union of India. Stop. Next slide. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within brackets CAPFS. On being qualified in preliminary round of selection process, petitioner participated.
For 1 second, my lord. If your lordships go through that Supreme Court judgment, your lordships knows that differences of the opinion.
Petitioner participated in the selection process. Petitioner participated in medical in detailed medical examination, which was conducted on 17 November 2025. Stop. Petitioner was declared unfit on account of Cubitus valgus. Stop. Cubitus valgus. VALGUS. CV capital. Stop. Petitioner. Such detailed medical examination was conducted on 17. Such detailed medical examination was conducted on 17 November 2025. Stop. Petitioner questioned a report of detailed medical examination by preferring review, and review medical examination was conducted on 26 November 2025. Stop. In review medical examination, petitioner was also declared unfit on account of Cubitus valgus, and medical experts on measurement indicated in review medical examination for in review medical examination angle in respect of right hand was 21 degree and angle in respect of left hand is 22 degree. Stop. Next paragraph. Learned advocate representing the petitioner submits. Now, learned advocate representing the petitioner disputes measurement taken in order to find out the angle, and according to the petitioner,
it will be Rampurhat Medical College. I am extremely sorry. I have told Murshidabad. Rampurhat Government Medical College.
One government medical college and according to petitioner, Rampurhat Medical College on examining petitioner prepared a report on 11 December 2025, whereby Now, wherefrom it appears that for right hand angle was angle is 14 degree and for left hand angle is 15 degree, which is under prescribed limit. Stop. Next paragraph. Clause Roman capital 7. Capital 7 within bracket 2 provides carrying angle as one of the grounds to declare a candidate unfit. Provided measured angle goes beyond prescribed range. Stop. As per clause Roman capital 6 within bracket 2. Normally, such angle is found to be within 10 degree hyphen 15 degree in males, and in female it is 15 degree to 20 degree. 15 degree এইভাবে ডিগ্রিটা লিখবে কিন্তু যদি পারো 15 degree to 20 degree. Stop. It is also provided therein that candidates with carrying angle up to 20 degree may be accepted if the same is not associated with abnormality of elbow joint. Stop. Next paragraph. In the present case, in review, in detailed medical examination, there is no indication of measurement of angle. In detailed medical examination, there is no measurement of angle. But in review medical examination, it was found that in left hand, such angle is 20, in right hand, such angle is 21 degree. And in left hand, it is 22 degree. Whereas Rampurhat Medical College, on examining the petitioner on 11 December 2025, measured in right hand 14 degree and in left hand 15 degree. Stop. Next paragraph. Since two divergent medical opinions are found on deformity of carrying angle, court finds it apt to direct All India Institute of Medical Science within bracket AIMS close bracket Kollani to examine the petitioner and file a report disclosing measurement of carrying angles in both hands of the petitioner on the next date. Stop. Next paragraph. Such report shall be prepared. Next paragraph. List the matter under the same heading for further consideration on February 2026.
Much obliged. Grateful to Lordship.
Stop. Next paragraph. Learned advocate for the petitioner is directed to communicate this order to the registrar M. Skolani by 28th January 2026 for taking necessary steps.
Much obliged. May I request one thing, Your Lordship? Last occasion, I have seen some learned advocate from the other side took this point that why this report has been sent to the petitioner side. May I suggest one thing, as per the sanction of Your Lordship, kindly indicate that same may be communicate to the Registrar General.
That will be convened, other it will take more time.
That
It is in the sealed cover, it is being placed.
Item number 15.
15, may I please, Your Lordship? I am for the petitioner. This is my affidavit of service here. My candidature has been rejected on the ground, page 19.
Defective distant vision.
Near and distance vision.
No, review says defective distant visions.
Well, at the page 19 is the initial.
Detailed
medical examination, first hurdle. Defective near and distance vision, both the
But it says defective
only
distant vision.
Left 6/12.
File report issue.
Well, I have checked.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner participated in the selection process for being appointed as Constable GD under Central Armed Police Forces within bracket CAPFS. Stop. Next paragraph. Nah, stop. Petitioner qualified in written examination and physical standard test. Stop. However, in review medical examination, petitioner was declared unfit on the ground of distant vision. Defective distant vision. Defective distant vision. Stop. Next paragraph. Union of India is represented by learned advocates. Next paragraph. Concerned respondent authority is directed to file a report disclosing as to why petitioner was declared unfit based on revised medical guidelines of May 2015. Stop. Next paragraph. Let such report be filed by 3 weeks from date. Stop. List the matter under the same heading for further consideration on 25th February 2026. Next.
Item number 16.
Yes, I appear on the is that he was appointed in the year 2006 through the employment exchange prior to the UMAD. 2003 the notification was that subsequently through employment exchange his name has been sent to the department. Subsequently he was allowed to sit in the written examination, became successful. Thereafter he was interviewed and appointment was given. Now when the appointment was given, it was written specifically that
petitioner was appointed in which post?
Group D post.
Where?
The district panchayat department in Jila Parishad. Through the
So it is under group 5 matter. Why group 6? See, you are seeking direction upon the principal secretary department of panchayat and rural development.
Admitted.
And is an employee of Jila Parishad.
No, he is the employee under the
Jila Parishad.
Under the Jila Parishad acting, but the district rural development cell is there. For such reason, probably it has been filed.
No. It's a panchayat matter, group 5 matter.
It has to be.
Where is your appointment letter?
Appointment letter is at page. Will get page 28.
28.
Absolutely. South Chowbis Pargana Jila Parishad. It has been written indicated, but executive officer South Chowbis Jila Parishad he has offered the appointment.
A legible copy is next page, my lord, page 29, my lord.
For a period of 1%. Minus 1 per month, taken from data field. Including the giving to be assigned. Issue. On hearing the learned advocate representing the petitioner, it appears that petitioner was appointed by the concerned authority of South 24 Parganas Zilla Parishad. Stop. Petitioner has also prayed for direction upon Principal Secretary, Department of Panchayat and Rural Development, Government of West Bengal. Stop. Next paragraph. Hence, writ petition stands released due to want of determination and be placed before the appropriate bench. Next paragraph. Leave is granted to the learned advocate to
Correct.
amend in the presentation form. It is written group 5.
That
Not in the presentation form. Then it would be sent to group 5 court. In the pro forma page, it is written group 5. In the presentation form, it is written group 6.
That means, my lord.
And Panchayat service, Panchayat is struck off.
But I cannot say that because, my lord, I am holding the.
What is the reason, Mr. Maji?
My lord.
What is the reason?
What is the reason? Lord, I cannot say, my lord, honestly, because my lord is Mr. Boydus.
Yes.
He has done it. Because we will get
leave
the
is
order.
granted to the learned advocate representing the
Admittedly, my lord,
petitioner
he has.
to amend the presentation form and reclassify the writ petition as group 5 matter.
But admittedly, my lord, we will get the order from this court. But
Grateful.
absolutely. Yes. Well,
Group 6.
Item number 17.
But I am item number 17. Mr. Pratik Mojumdar, who appears for the DVC in this matter, had to leave town yesterday due to some family medical emergency. I have been requested to pray for not this week, Lordship.
My lord, only thing, my lord, I have challenged an order of transfer. My salary has been stopped.
It will come back not this week.
Then it will retain its position, my lord.
Yes.
Grateful.
Item number 18.
For the petition.
Plus, your lord, the leave of your lordship, my lord, I am appearing virtual, my lord.
Yes.
Affidavit of service. The petitioner.
Louder, please.
Sorry, your lordship.
I cannot hear you.
Sorry. The petitioner before your lordship was initially appointed as lower division clerk in Raja Rammohan Roy Library Foundation, your lordship. Thereafter,
Then why you are not moving the court having the determination to take up library service?
no, your lordship. What the main issue here is, your lordship, that she, while in service in Raja Rammohan Roy Library Foundation, she applied for a post of junior executive in IIT Kharagpur. This issue is relating to the lien, which she was not granted from Raja Rammohan Roy Library Foundation.
Release order.
No, release order was granted, your lordship, but she sought for lien, which she was rejected.
But it's a library. Your prayer is relates to your service rendered as a staff of the library. So there is a specific determination so far library is concerned.
She was in the administrative department, your lordship. So that is why it has been filed under group 6 service, your lordship.
Chairman Raja Rammohan Roy Library. Show me the determination chart. Look it out. Including library service. there is a stipulation. Who is taking other education matters?
College and library is taking Justice Mitra, my lord.
Yes, Your Lordship.
Yes.
Justice Rito Pratap.
Code number 24.
Code number 24.
Motions and matters under Article 226 Constitution relating to library, college and university under Group 2.
Your Lordship, at present, she is not working in the library anymore.
But you are seeking a direction upon an authority of library.
Yes, I am, Your Lordship.
Then why you have chosen this code?
No, it is not that, Your Lordship. It is just that it was a service.
Matters are coming as per presentation form.
Lordship, not at all. It is an
Then I will shun this system and direct all matters to come in the combined list.
No, Your Lordship.
Because I am noticing this, that the matters from other determinations are being filed before me, terming it is a Group 6 service matter.
No, Your Lordship.
You have seen just now the previous matter.
We were under this impression that it is a service related because she is in the administrative
And
department.
this is happening regularly.
Code number 24.
Issue. Matter relates to library. Stop. Hence, writ petition stands released from list due to want of determination and be placed before the appropriate bench. Next paragraph. Leave is granted to the learned advocate representing the petitioner to amend presentation form and pro forma page of the writ petition and to reclassify the writ petition as library matter.
I'm grateful.
I tender my apology, Your Lordship. Kindly do not miss out.
Item number 19.
Item 19, I present my lord all the respondents.
Yes.
The second round of litigation by ESS constable who was dismissed from service for overstaying leave. 200
Dismissed from service.
Yes.
Yes, is it an appellable order? Where is the dismissal order?
Statutory petition was filed and that was rejected.
Whether the dismissal order is dated 8 September 2025?
Lord,
Dismissal order.
Speaking order in compliance with the court's order?
page 25. Page 25. 18.
You are challenging page 59?
I'm challenging 59 as well, yes. But original dismissal order is as page 25. 122 pages.
Just a minute. So there is a direction for consideration of representation.
My lord.
Where is the order passed by the coordinate bench?
By the
Where is the order passed in the writ petition being WPS 6343 of 2025?
my lord, it is at
the page 57.
my lord. It's page.
So there was a departmental appeal which was pending, which was directed to be disposed of by the court. Against this order, whether any review application is maintainable or not? Is there any provision for revision?
An appeal has been preferred.
Yes.
An appeal was preferred.
Yes, I couldn't hear you. Yes.
Lordship, against the order of dismissal, an appeal has been preferred.
Appeal, in the appeal, the order of dismissal was affirmed. Now, against this order of the appellate authority, is there any other authority where the charged employee is entitled to seek revision of the order of the appellate authority? Generally, such provisions are found in other organizations. That's why I'm asking you. You have to enlighten this court on this issue.
Lordship, in this matter, my lord, I have to in my lord, my lord, my lord.
Yes.
Lordship, in this matter, I have to obtain my lord.
Instruction. Mr. Dasgupta, in BSF matters, is there any provision for revision?
Possibly.
Against the order of the appellate authority?
BSF act karo. Review dekho.
Or it is the final order?
No.
So far department is concerned.
Review search karo, review. Review or revision search karo.
Are you aware of?
No, there is no.
Very well, let him take instruction.
There is no such review, my lord. There is no such review.
Very well, let him take instruction and come back.
Are you lord?
For
a short revision.
Yes, in the writ petition, order of the appellate authority dated 8 September 2025 is questioned, whereby order of what was the punishment inflicted?
My lord?
What was the punishment?
Dismissal from service.
Where is the order of the disciplinary authority?
Page 25. And that also by second in command, not commandant.
Where is the recording of punishment?
Pardon, my lord?
Page 25, 26, where it is recorded that petitioner is to be dismissed from service.
Yes, Lord. It is recorded in paragraph 3. Considering the matter is in its entirety, I am satisfied that number so and so, constable so and so, has been illegally absenting without sufficient cause, overstaying leave since 9/10/2021. I am also satisfied that his aforesaid continued illegal absence is contrary to the expected norms and detrimental to the post discipline, which makes his further retention in the post undesirable. I therefore direct the said number be dismissed from service with effect from 18th May.
কি বলছিলাম? Of dismissal dated 18th May 2022, passed by the disciplinary authority, was affirmed. Next paragraph, on query being posed to the learned advocate representing Union of India whether any provision exists which grants opportunity to the petitioner to question the order of the appellate authority before the revisional authority or not, comma, accommodation is paid for. Next paragraph. Hearing of this matter stands adjourned in order to enable the learned advocate representing the Union of India to obtain necessary instructions. Stop. List the matter under the same heading for further consideration on 28 February 2020, 28 January 2026.
Item number 20.
But I am appearing for Union of India.
Yes.
Disciplinary is an unqualified candidate participated in, my lord, selection procedure for CRPF, my lord. Whereby you are
Constable.
constable, my lord. Unqualified due to non-qualified due to, my lord, height, my lord. The
Not
prescribed-
qualified in
not
terms of height.
In terms of height, my lord.
What was the height measured?
Height measured, my lord? It is at page number 24, my lord.
24.
24 of my report. This is the rejection speed, my lord.
Page 24.
24, page number 24.
169.2.
164.9.2, my lord. The
Page 24.
yes, ma'am.
169.2. Yes.
9.2, my
Yes.
lord. The prescribed height was, my lord, 170. My lord, on 2024, he participated in similar selection procedure, my lord. He was declared, his height was declared to be 170.2, my lord. That was also annexed. That is also annexed to my petition, my lord. Is at page 21, my lord. Thereafter, next year he participated, and in that proceedings he was declared unfit due to, my lord.
So you are relying upon the height which was measured in connection with 2024 selection.
Selection procedure, my lord. Annexed at, my lord, page number 21. 70.
Are you aware of the judgment of the division bench in Harun Mia?
I am not aware of that.
That issue has already been decided, that the measurement taken in the previous selection process is not relevant. So you go through the judgment and come back and address this court.
My lord, I do have a
Take
copy of
down.
my lord's order, whereby my lord directly.
You need not on this issue. Please read Harun Mia. Take down. FMA 964 of 2025.
FMA
964 of 2025. Harun Mia versus Union of India and others. Recent judgment of the division bench headed by our Chief Justice, and the judgment is dated 11th September 2025. Take a printout, go through the judgment, come back.
And my lord, I am also relying on another document at page 29, my lord, whereby the
Issue. Matter is heard in presence of the learned advocates representing the petitioner and Union of India. Stop. Hearing of this matter stands urgent in order to grant stands urgent in order to enable the learned advocate representing the petitioner to come better prepared.
My
Stop.
lord, may I submit one page more, my lord?
Over affidavit service to come back, list the matter under the same heading for further consideration on 28 January 2026.
28 some personal difficulty.
29.
Why? Where are you going on in the midst of the week?
Someone is coming out from outside.
Very well, 29 January.
Great.
Go through that judgment.
Great, my lord.
I could have dismissed the matter today because the issue is no more res integra. Go through it, come back.
I'm grateful.
May I need to mention my one assignment complete petition. So kindly read it. It is in the motion stage, first matter with the motion stage.
Under which group?
Corporation.
Huh?
It is assigned.
At one point of time, I heard the matter.
Date is on application for addition of one of the person who claiming as a file an application for addition of parties.
Now, I disposed of the matter.
Not disposal, only that one application for addition of party was malord.
Against the which appeal was preferred. Directing.
Directing them to give them also the right to be. So that matter.
When it has been assigned.
It is assigned before that, when the matter came to the law.
Oh.
The petition was came before the lawsuit was assigned.
Then as assigned matter, I passed order on addition of party, application for addition of party, which was dismissed, but subsequently in the review, in the appeal, the appeal was allowed and the parties were directed to be added. What is the urgency?
Urgency is that my building is totally complete. But my lord, due to some objections of the private respondents, my lord, the corporation is not giving me the occupancy certificate, connection of the water, connection of the drainage. These are the things, my lord, which cannot be, my lord, wait.
It is at the hearing stage. And what about the 2015 matter?
That is same.
The affidavits are complete.
No,
in 2015.
first one is not complete, second one they have not given any.
And in the first one, there was a direction for affidavit.
No. Only your lordship dealt with the matter for the action.
February assignment.
May I permitted to mention one matter. Lordship was pleased to grant time to file supplementary affidavit within fortnight. That is going to expire on 22nd. I am seeking some more time. This is a Red Cross matter. I could not gather information on the things.
When matter was directed to appear?
Monthly list of February.
देखिए तो issue. Matter is mentioned by the learned advocate representing the petitioner, seeking extension of time to file supplementary affidavit, as it was directed VDA order dated 7 January 2026. Stop. Time to file, next paragraph. You are you have not served notice upon other side?
No, the last 3 occasions we have served, never had, so administrative notice was issued.
Time to file supplementary affidavit stands extended by 7 days. Stop. Time extended for filing supplementary affidavit is peremptory. Stop. 7 days extension.
May I have my lord's kind leave to mention item number 20. I have filed a G application which is appearing in the lordship's list. But that G application I mentioned on the last occasion, but your lordship, please.
Item number
20. That is appearing.
20.
It is appearing on monthly.
Combined list.
monthly list.
Yes.
I have filed an application for G, which is appearing in the monthly list, my lord. That in the G application, I have paid for an interim order pursuant to the direction given by the earlier coordinate bench. But I was supposed to be given a contract form, which I will be signing along with the managing director of the corporation for enable me to join the duty. That I have made representation pursuant to the earlier order of the coordinate bench, but that was been denied to me. And as such, I could not join the organization. I am a contractual driver. But that order I am seeking for your lordship, my lord, unless they give me the contract form, and
When I will take up this matter, then you will.
let it appear as an application before lordship.
It is already appearing in the list.
But your lordship, under the heading for hearing, it is appearing. Let it
Let-
appear.
No, sorry, I will not upgrade in this fashion.
My lord,
Yes.
Upon
may I
notice
be
I mentioned.
permitted?
No,
My
no.
lord, I'm seeking your lordship's indulgence, my lord. I understand, my lordship is not taking up hearing matters, but my urgency, lordship, is that this is a 2024 matter, my lord, where I am a trainee pilot engaged with Shama Prasad Mukherjee Port. And my lord, I have challenged the rules and regulations because they have not permitted me to sit for my exam. Now, my lord, affidavit directions were passed, and my lord, the main answering respondents, despite having given them 3 chances, have not filed their affidavits. The last chance was given, my lord, on 3rd August 2025. And now the order records that it is the last chance. They have not given it. The matter, my lord, has not come up. The only difficulty, my lord, is I had mentioned, and I was informed that lordship is not taking up hearing matters. But the difficulty is the port is now threatening this employee, my lord, the petitioner, that he will be sacked and he will be removed if, my lord, it
If
is
he
not
is
taken
removed,
up.
then remind me.
My lord, if lordship will at least grant me an interim protection, or at least, my lord, renew the direction upon the respondents.
May I permitted to mention one matter for withdrawal, your lordship?
You don't want to proceed?
Yes, your lordship.
Yes, to be mentioned on next.
My lord, at least can these be included in the list, lordship? My lord, I will pray for an.
I have disallowed mentioning of others for inclusion. When I will include permit inclusion, I will include all. I will allow all mentioning.
But my lord will kindly give me the indulgence, lordship, that in event that any adverse steps are
Yes,
taken, I
yes.
shall
You
inform your
bring the
lordship.
notice of this.
Grateful,
At the
ma'am.
cost of
Grateful.
repetition, I'm not seeking for hearing of the main writ petition, only the GA application, my lord.
When you have filed J.
But I have filed GA, my lord, it is appearing in the list, my lord, immediately when they have been denied. Immediately thereafter I filed.
When denial?
But then I will have to take the, it has
Yes.
been affirmed, my lord, it has been
Yes.
affirmed immediately.
When you are denied?
But the denial letter is already annexed.
When you were denied?
That I will have to take.
In 1905 or in 2025?
No.
Tell me.
2025.
Yes.
Just pujafication. Just of the when they have denied to.
When you have filed the application?
The GA application is GA1 of 2025. My lord, it is after pujafication. Immediately.
Wait for some time, let me see.
Original side matter, item number 1.
My lord, item number 1, we appear on behalf of the
Yeah, my lord.
respondent 1. I am appearing along with Ms. Monica Rai.
This is a case here, my lord, we have participated in the examination.
Order copy gulo dao, যদি কিছু থাকে। Oh, order নেই, first step. Yes.
During the process of our examination, my lord, the criteria and my lord, rule of game has been changed. This is the rule of game has been changed during the pendency of the selection process. This is the, my lord, main issue in this writ application. If your lordships kindly come page 34. Discipline is, my lord, finance. This is the advertisement, my lord. This is advertisement of 25th February 2025. That is at page 32.
Who are representing respondents? You are representing?
My lord,
I'm representing the Coal India, my lord, led by learned senior advocate, my lord, Sumit Sharma. He is in the virtual mode.
Yes.
My lord, if you lordships kindly come page 32, my lord.
32?
My lord. This is the advertisement of 25th February 2025. For filling up the post of, my lord, various discipline from the departmental candidate itself, my lord. Now, if you lordships kindly come next page, page 32A, my lord.
Yes, page 32.
My lord, next page, if you lordships kindly come.
It is what? Notification for recruitment?
Yes, my lord. For various discipline, we are, my lord, concerned about, my lord, finance discipline, my lord. Now, next page, at, my lord, serial number 5, you will also will find, my lord, the minimum qualification and minimum experience.
Serial number 5.
5. Finance discipline, my lord. You also got it, my lord. Now, my lord, who are, my lord, the eligible, my lord? The persons, those who have, my lord, final, sat in the final exam of CA / ICWA.
Where from you are getting this?
My lord, at
Final examination of
page 32A, my lord, next page.
Page 33.
32A, my lord.
32A, man.
Next page of
It
32.
is not paginated.
No, no, that is not page. What page? Page.
Sorry, my lord.
Final examination of CA ICWA.
Yes, my lord. Final examination of CA / ICWA. Minimum experience is nil at right side, my lord. And thereafter, my lord, inter-cost, chartered, and CIL accounts.
What is TS grade? T and S grade.
Technical
experience in technical
and supervisory grade.
Supervisory grade.
My lord. And now graduate. So these are, my lord, 3 criteria who can, my lord, appear in the examination from the department itself. To be
so you participated in the selection process?
Yes. I'm
for appointment of for recruitment in which
yes.
post?
For, my lord,
what is the post?
From non-executive to executive cadre, my lord.
Whether the post is
They are non-executive.
Indicated in page 32.
Yes, my lord. For promotion, selection of departmental employees from non-executive cadre to
it's a case of promotion.
Promotion.
So you are already working in Coal India Limited.
Coal India Limited as well as non-executive.
Non-executive.
My lord. Now they have changed, my lord, their criteria.
From non-executive cadre to executive. Under which discipline? For which discipline you?
Finance, my lord.
Finance.
My lord.
What is the promotional post?
Promotional post executive, my lord. Will be executive E2 grade. As and when will be selected, my lord. From non-executive to executive.
Yes.
Now, you also will find, my lord, the finance discipline 32 NR. Now, my lord, if you also kindly come, page 34, you also will find, my lord, the vacancies. Again, my lord, 5. Total vacancy 86.
85.
Finance is 86, my lord. Page 34.
Finance.
My lord.
Yes, again serial number 5, total vacancy is 86.
86. Now, unreserved is 51. SC is 19. ST is, my lord, 16.
Yes.
Now here, my lord, we have, my lord, my lord, belongs to scheduled tribe and scheduled caste candidate. One is scheduled caste, others are, my lord, scheduled tribe. Now, these are, my lord, the advertisement. Now you also will kind come. First notification of page 56, my lord. After this, my lord, we have, my lord, applied. Now page 56, you also will kindly come. The candidates who have submitted their application against notification number such and such, which I have just now shown to your lordships, issued in regard to promotion / selection of departmental employees of executive cadre in 16 disciplines, are hereby informed that the computer-based test will be conducted on 29th November 2025, Saturday, from such and such and such.
Page
56. This is the notice of 30th October 2025. They have informed that the examination will be held on 29th November 2025.
CBT. Yes, 29 November.
29 November. Now, my lord, next page, your lordship will kindly come. This is the impugned before your lordships.
What you are praying for?
I am praying for cancellation of this notification because because they have changed, my lord, the criteria. We have, my lord, participated, we have, my lord, applied for the posting question against the particular vacancy, and after that, my lord, just few days before the examination, they have changed. That is the page 57. If you also kindly come.
Yes, demonstrate.
My lord. Now we are, my lord, there are, my lord, two groups. One is qualified group, one is semi-qualified. We are, my lord, fall under the semi-qualified group. Now you will also will find in a semi-qualified group, they have, my lord, reduced, my lord, the candidates to be selected SC 3, ST 2, which they cannot.
How you are saying that they have reduced?
Kindly see, my lord.
In comparison to page 34.
34.
Yes, but there is a subdivision of qualified and semi-qualified.
Yes.
Yes.
Now in this page 34, you also will find
if you aggregate 16 plus 3 under SC, there are 19 candidates.
Yes.
And in page 34, there are 19 seats reserved for SC category. And under ST category, total seats reserved is 16.
Yes.
And in 16, qualified, semi-qualified and qualified, if you add in that event qualified 14 and semi-qualified 2, it comes to 16.
16.
So there is no change in identifying the reserved category candidate posts for reserved category candidates.
Yes, my lord. Here SC semi-qualified 3, because we are come under the group of semi-qualified. They have now segregated qualified and semi-qualified. In the initial notification, there was no segregation. Everybody will sit in the examination because these are the qualifications.
It's not a change in rule of game. It is for identification of vacancy. But under qualified and semi-qualified.
Now, my lord, if you will kindly come, my lord, the page 32A, my lord.
And that is permissible. In case of West Bengal Judicial Service Examination 21, Division Bench delivered judgment in more or less on similar facts.
Well, if you also kindly
it's
come,
not a change in rule of game.
Because if you also kindly come page 32A, my lord, you will also will find the 3 categories of, my lord, qualifications will come under the, my lord, same, my lord, stand.
Total number of vacancy remains same.
Total number same. But
total number of reserved vacancies under ST and ST is constant.
Same. But here
it has been bifurcated into qualified and semi-qualified group.
Yes, this is
wrong.
Because we have, my lord, sat in the examination with the my lord, expectation that we will compete 19 or 16. In a case of SC, we will compete within the candidate of 19, and in a case of ST, we will compete within the candidate of 16. Now they have reduced, my lord, 2 and 3. So this is, my lord, the change, and, my lord, the reducing of the number of the scheduled caste and scheduled tribe.
It's not a change of rule.
But they have reduced.
It's a question of identifying vacancy under different categories.
But let they show the rule.
But the total vacancy remains same, reserved vacancy.
Total vacancy, but we cannot, my lord, go beyond 2 and 3. We cannot go beyond 2 and 3. We have to, my lord, compete within the, my lord, 3 candidates and within, my lord, 2 candidates.
Yes, what is your instruction?
Now, my lord, if you also kindly see, there,
yes, what is your instruction?
My lord, change
my lord, my lord, there has been no change in the rules. First of all, my lord, I would have raised this point of maintainability because they have already participated when the circular was issued. Now, my lord, keeping aside the point of maintainability, may I submit, if your lordship has taken into consideration the subsequent notification which is impugned before your lordship, it only states that the persons, those who are, my lord, those who have obtained the certificate,
who are treated as qualified and who are treated as semi-qualified.
Qualified means a person who has attained the certificate, because in CA there are 3 grades, as far as subject to correction, and the semi-qualified are the persons, those who have, obtained the first grade or the second grade. So, they remain in 2 footings, and that is, has been clarified. If your lordship looks into the total vacancy position, 86 remains 86. And my
No,
lord,
but
if your
why
lordship,
this was not indicated at the time of notification on 25th February 2025?
because my lord, it follows from the my lord, departmental circular itself. This position was, my
No,
lord,
but that has
amended.
to be indicated in at the time of initiation of the selection process or promotional
Yes.
process.
Yes, but my lord, these 20%
Why
can
this subclassification in the midst?
Secretary, it's not in the midst, my lord. It flows from the 2014 amendment itself. The rule that has been, my lord, mentioned, if your lordship take into consideration the circular, the impugned
No,
circular.
you have stated you have come to page 34, tentative vacancy.
Yes.
In tentative vacancy under general category 51, SC 19, ST 16.
Yes. But
Now,
if your lordship
now
also,
there you could have subclassified the vacancies under qualified and semi-qualified. That you have not done.
but the
Now,
qualification
petitioners
is
are under the impression that they are competing against a vacancy of 16 under ST and 19 under SC. How that is permissible?
well, this is, well, this flows from the departmental circular itself. The circular
You have
from
done.
which
See come to page 34. See the last column. Category,
yes.
subcategory of disability suitable for the post.
Well,
There
that
is subcategorization under 2016 Act of disability.
That is disability act.
See the last column.
Yes, my lord. We
Visually
have,
handicapped LV2, hearing handicapped 1, orthopedic handicapped. There are further subclassification OAL, BL, OAL,
absolutely,
BLO.
my lord. That flows
1
from the
and
statute itself.
MD miscellaneous deficiency 1.
Yes, absolutely,
Because
my lord.
why this has been done? This has been done in terms of
Because this is a statutory provision.
2016 Act. So in
Yes.
case of semi classification or in case of semi-qualified or qualified, this subclassification ought to have been notified at the time of identifying vacancy. Why this was not done?
Absolutely, my lord. Now, if your lordship has taken into consideration that sub-classification of physical, my lord, differently abled person, your lordship has seen that it flows from a statute itself. Similarly, my lord, this sub-classification, it flows from clause 1.15 of the Coal India, my lord, HR manual.
So therefore, this sub-classification is not required to be made at the time of initiation of promotional process.
My lord, these these are working.
How does it matter if it is provided under the substantive plenary law and under the circular of the department? You are to notify the sub-classification at the time of initiation of promotional process.
Yes, but my lord,
why you have not done this?
Yes, but lordship will also consider one aspect that the person, those who are semi-qualified, they know that their qualification is semi-qualified and they are, my lord, to compete. They cannot, my lord, have a same footing of the qualified person. This is also to their knowledge because some of the candidates are participating in 2016 selection process and clause 1.15 is not under challenge before your lordship. That is, my lord, the HR manual
They are not
of the promotion.
They are not required to challenge clause 1.5. They are not saying that this sub-classification is wrong. They are saying that in the midst of selection process, this sub-classification is impermissible.
No, my lord, this sub-classification, my lord, if I may humbly
because
submit
candidates
in this,
are under the impression they are competing against 19 vis-a-vis 16 posts reserves under ST and SC.
SC category, which was initially advertised.
How you can do
the
this?
Initial advertised.
You could have, if it is their departmental circular or departmental regulation, you could have done this at the time of identifying vacancy, that is page 34.
Yes.
That is the part of the notification dated 25th February 2025. Why at in the midst you have done this?
This is not in the midst of, after the advertisement, before the exam was conducted, my lord, it was published. Lordship will kindly take into consideration for once. My lord has already looked into it. Lordship will kindly take into consideration and accept P5 at page 57. Kindly, my lord, for once. My lord, may I just read it out for your lordship, my lord, for once? In accordance, page, my lord, annexure P5, page 57. Your lordship has looked into it. My learned friend has already, my lord, referred to that. At the cost of repetition, my lord, I will just once indicate that it is an notification dated 24th November 2025, prior to the exams. Now, my lord, it is prior to the exam. It is in the between of recruitment notification and the examination. So, my lord, the person, those who are sitting in the exam, has already looked into the sub-classification.
Is a notice relating to compute CBT.
The computer-based test.
Yes.
Computer-based test.
Yes.
So,
what you want to submit with regard to this notice relating to CBT?
my lord, two things, my lord. One is the date of the notice. The date of the notice is 24th November 2025.
Date of this notice is dated 30th October 2025.
Well, I'm referring to 24th November
Page
2025.
56.
Page 57, my lord, I'm referring to, my lord. Page 56 is... Page 56 is, my lord, the announcement of the date of examination. My lord, kindly, my lord, looks into the next page. It is dated 24th November 2025.
But online application last date was 27th of March 2025. Page 32.
Yes, yes, absolutely, my lord. I'm coming to
and
that.
you are notifying it in 24th of November 2025.
Yes, my lord, the language kindly, my lord, looks into it.
So why you are taking this point that after participation they are challenging? Because they didn't have any other option. Had it been notified prior to 24th of prior to the last date of, that is 27th of March 2025, the question would have been different.
I mentioned that
you issued this notification on 25th of February 2025, fixing the last date of submitting application on 27th of March 2025, and you are notifying sub-classification on 24th November 2025.
November 2025. Yes, my lord, that is the date, and my lord kindly looks into the language.
This point that after participation, what petitioner will do? Petitioners have applied. Petitioner had to apply prior to 27th of March 2025.
I use the language before going into the test, before giving the test.
How does it make any difference? Because petitioner has already offered candidature.
Well, yes, the admit card was issued. This
but blowing hot and cold, and the petitioner, if comes before this court, then they have the maintainability will be questioned.
No, my lord. It is not
Why
on the point.
You have not notified sub-classification prior to 27th of last date, that is 27th of March 2025? Tell me.
My lord,
I ingrained in your rules.
Yes, my lord, it is there.
Why it was in the midst after inviting application and last date of submitting application?
Yes, my lord, it is in, my lord, I would only at the cost of repetition. Even
what is the ratio of Tej Prakash Pathak?
My lord,
by the then Chief Justice of India, bench headed by the then Chief Justice of India.
My lord, in that case, if I may say so, my lord, this my lord, may I come back with this thing, my lord, because this period which your lordship has indicated, my lord, I will bow down to your lordship.
I will stay the promotional process.
My lord, will kindly, my lord, allow me to get this instruction and come back. Then your lordship takes, because already the examination is over. Now, my lord, the results are awaited. Now, my lord, in the midst, my lord, because there are other categories also. If your lordship stays this notification, my lord, in my respectful submission, there are other categories also, which has been indicated, apart from the, my lord, scheduled caste and scheduled tribe classifications. So, my lord, may I respectfully
Yes,
submit,
I
my
will
lord, may I
induct
come
the
back?
Coal India Limited from giving effect to the promotional process. So far, it is confined to scheduled tribe and scheduled caste
My lord,
candidates.
my lord, will kindly, my lord, bear with me for another week, my lord. Then may I come back? Which your
Simple
lordship.
thing, you are saying that it is as per your rules or regulations.
Yes.
If it is as per your rules and regulations, why this subclassification was notified? That is page 57. VDA notice dated 24th of November 2025 after last date of submitting application.
Yes, if I have understood your lordship correctly, my lord, your lordship, my lord, the point remains is why it was not, my lord, indicated in the initial advertisement or any date prior to the, my lord, submission of the application. Well, if this notification, what you has fallen from your lordship, if this notification was issued prior to that, there would have been no confusion. Now, my lord, the point remains is why it has been, my lord, indicated 5 days or 6 days prior to the examination. Well, this is the only point that
only based on CBT it is to be done, or on CBT and yearly assessment. What is the present status of this promotional process?
But what I have been instructed is that the results are awaited.
Yes.
So, my lord, let me come back. Let me come back. The final results are awaited. This was my instruction. The examinations are over. We are not awaiting
So
the
don't
results.
publish final result in the meantime.
But your lordship kindly gives me, my lord, a week's time.
No. In the meantime, you will hurriedly
No, my
publish
lord.
the result. No.
No, my lord. This much, not in this month, the results will not be published. I will come back before your lordship on 28th, because your lordship takes up original side on 28th, and appellate side matter on the similar point is also pending before your lordship. My lord, your lordship kindly grants me a time till 28th. Till 28th, my lord, kindly doesn't pass any order. In 28th, I will come back with all the instructions that has fallen from your lordship. If I have understood your lordship correctly, my lord, this point that this notification, if it was published prior to the last date of submitting the application form, it would have raised no confusion. Malad, if I have understood Malad correctly, Malad, let me come back with these instructions as to why it was published at a belated stage. Nothing more that I will Malad visit your lordship Malad to consider right now.
Who are treated as qualified group? Those who are having the certificate.
Well, yes, the qualifications.
And who are semi-qualified.
Semi-file, my learned friends, clients, those who have, my lord, crossed grade 1 or grade 2. As, my lord, as subject to correction, as I know, my lord, there are 3 divisions in these examinations of, my lord, obtaining this certificate. Grade 1, grade 2, and grade 3. Grade 3 happens to be the final, when they obtain a certificate. And semi-qualified are those persons, my lord, subject to correction from my learned friend.
Who are qualified and semi-qualified?
Page 57, if you kindly come.
Page 57.
It is defined.
Yes, page 57.
Well, kindly see the promotion selection from non-executive to executive cadre in finance discipline, 50% quota is reserved for the qualified CA and ICWA group, and 5% quota is reserved for semi-qualified group within bracket inter-cost / chartered accountant, chartered and CIL accounts exam part 1 or graduate. So this is the semi-qualified. We are coming under the malord.
So it is based on qualification.
Based on
qualification.
Yes. Only CBT is the malord, the examination malord.
1.15 of this. This is manual for promotion selection from
or graduate.
Just a minute. In the finance discipline, 15% quota is reserved for qualified CA and ICW. CA and ICW. For qualified CA. And 9% quota is reserved. 15% quota is reserved. 15% quota means 15% of the entire vacancy.
Out of that 20%, which is reserved for the my lord, our own my lord
norms.
Yes, 80% is for the external, 20% out of the 20%, 50% is for the qualified group, and 5% for the semi-qualified group.
Now, this 20%, 15 plus 5, 20.
Yes.
Of what? 20% of what?
The entire strength that will be bringing in by this selection process. 80
Entire
plus 20.
vacancies for promotion.
Yes. Your lordship has looked into the notification.
Suppose
out
there
of
are
which-
100 posts. Suppose
Yes,
there are 100 posts. Then 20
Yes.
posts are to be reserved for scheduled caste and scheduled tribe.
No, from the department.
No, my lord. 20 posts is
From
to
the
be
department
reserved
and
for
80 for open category candidates.
And out of
Now,
Yes.
out of 20,
Finance
if
discipline.
there are 100, then 20 for
Yes.
departmental promotion. Now, out of 20,
Yes.
this
15%
15% of 20 is to be reserved for qualified.
My learned friends clients, for my learned
Qualified.
friends clients. And 15% for the qualified persons.
So you are that this is 15% is qualified departmental candidate.
Departmental candidates.
Yes, yes.
And
yes.
5% for semi-qualified departmental.
My lord.
Departmental candidate, yes.
Then what about this open category candidate?
80. Suppose 100.
And what about general candidate, general category departmental candidate?
Well, that is not the 16.
My lord, that your lordship will find into this notification. Your lordship looks.
Suppose there are 100 vacancies,
My lord.
which are to be considered for promotion.
My lord.
Then you are saying that 80% is kept for open category
Open.
candidates who are outsiders,
My lord.
and 20% for departmental candidates.
Department.
Now, if out of this 20%, 15% is reserved for semi-qualified reserved category candidates.
Qualified.
No, my lord, not for reserve category candidates.
Qualified person.
For qualified reserved category candidates, and 5% for qualified. No, 15% for qualified reserved category candidates and 5%.
Not reserve. 50% from
Reserve
qualified.
candidate for all candidates.
Qualified all category candidates.
All candidates, all qualified candidates, unreserved candidates also come under these 15%. Those who have had the qualification.
Also, my lord, we are also eligible for the other
But
disciplines.
if there is another aspect,
My lord.
that it is not if this is it is stated in paragraph page 557 in accordance with clause 1.15
Yes.
of Coal India Human Resource Manual.
My lord.
So that system is prevalent.
But it is not indicated in the advertisement.
Maybe, but that system is there already.
My lord, if you lord kindly see, my lord, the last
Or
annexure.
every year it happens.
No, this is first time they have introduced. Otherwise, my lord, we are also eligible for the other disciplines like personal and others, my lord. So because
No,
of this only,
1.15 was inserted in CIL HR manual, not in this year. Previously
my
it
lord.
was provided.
Provided.
So following 1.15, whether in previous year same system was prevalent.
there is a conflict. If you lord kindly see, my lord, the page 72, the cadre scheme, there are, my lord, different categories of rules prevailing in the coal industry. Kindly see, nothing has been, my lord, mentioned in respect of our discipline. Office memorandum of page 72, last annexure.
56.
CIL board, may I read one?
So therefore, please come to page 34.
34.
Vacancies are identified under this table as appears from this table.
My lord.
Under the finance discipline, there are total 86 vacancies.
86.
These 86 vacancies comprises of 20% of the total vacancies.
Yes.
Because 86 is for in-service category candidates.
Yes, 20%.
Giving promotional revenue.
Yes.
Now, these 86 are subdivided into 51 plus 19 plus 16.
16.
Plus 16. Now, out of this 86, 15% of 86 is reserved for qualified candidates.
Yes.
And rest 5% is reserved for semi-qualified candidates.
Yes. My lord.
Now, this subcategorization in between qualified and semi-qualified is done. Then thereafter, applying clause 1.15, this categorization subcategorization was made.
In the mid. That is hits, my lord, the
But that is prevalent in your that is already there in the rules,
But my
in clause. in clause 1.1.5,
Lord, they-
1.15.
My lord, at the time of initiation of the, my
Is
lord,
it a case that the first, for the first time it has been
first
done?
time,
Previously, there was no categorization
No.
in between qualified and semi-qualified.
no, that's why they have, my lord, this
Mr.
time.
Sharnal, previously there was no
So,
subcategorization.
there cannot be, Malad, these instructions I will have to take because this point came out because in 2014 this was amended. This HR manual was amended and
2014. So what was
2014.
the system followed in prior to this selection process, this promotional process, you obtain instruction.
Yes, and my lord, kindly, my lord, 2014 circular also will place before your lordship, wherein the subcategorization was categorically mentioned and this clause 1.15 was amended.
See, my lord, the last annexure, page 72. But may I read? This is very vital, my lord. Last annexure, my lord. At the initial stage, had it been, my lord, the disclosed to us, we would have applied for the other disciplines because we are also eligible for the other discipline as well. Your personal discipline, if you also kindly see 142, we could have, my lord, applied for the personal discipline. And graduation is there.
But in all discipline, this has been done.
No.
Has to be.
No. Only in respect of our case.
In finance discipline only this has been
Yes.
done.
Yes.
Malad,
Why in
may I
other
read out?
discipline? Why
No,
in
no,
other
Malad,
discipline this has not been this subcategorization has not been given effect to?
My lord, may I just say this because there is an system of fully qualified person and semi-qualified person.
In finance discipline.
Yes, in finance discipline, a person has to obtain a complete certificate after 3 courses, and a person only crosses one hurdle. So, my lord, they cannot be in the same footing. Anyway,
Then
my
show
lord,
me, do you have the copy, this 1.15 of CIL HR manual?
Yes.
Show me.
But before that, my lord, may I read, my lord, page 72? I have.
Please show me this 1.15. 1.15.
the amendment was brought into effect in 1st January 2014. My lord, I have a copy with me, but unfortunately, my lord, I have to place it on record because this copy
Just a
clearly,
minute.
my lord, states.
Please wait.
Sorry, my lord.
No, Mr. Ghosh. Again, serial number 2 finance, direct recruitment 80%, and departmental selection promotion 20%,
Yes.
within bracket 15% qualified, CA qualified, chartered accountant and ICWA.
Yes.
Slash 5%
Yes.
semi-qualified, that is inter chartered accounting. Already there.
The answer is, my lord, 65.1 of the Constitutional Bench judgment of the Honorable Supreme Court, Tej Pokas. Same thing has been considered. Now, apart from this, my lord, if your lordships kindly come, page 72, my lord.
Page 72.
Well, had it been they indicated in the advertisement, I could have applied for the other discipline because we are also eligible. Graduation is also there.
No question of other discipline. It is for finance discipline.
Yes.
This is a specific stipulation.
Yes, that I understand.
Knowing fully well 1.5 you have applied.
No, because we have applied.
Because this promotional process is being conducted in terms of this HR manual.
My lord, they have in the advertisement, nothing has been spelled out. Had it been, my lord, they have, my lord, specifically mentioned because subcategories they have mentioned. Lightly, your lordship has pointed out, subcategories they have mentioned in the advertisement. Had it been, they have, my lord, may I, my lord,
File your affidavit, sorry.
well, the circular, my lord, circular kindly, well, allow me page 72. Kindly, my lord, page 72.
Further, sorry. Matter is affidavit. No, matter is heard in presence of the affidavit of service taken audience. Matter is heard in presence of the learned advocates representing the petitioner and Coal India Limited. Stop. Petitioner is aggrieved by subcategorization made by the concerned authority of CIL, Coal India Limited, herein after referred to as CIL or for short CIL করে দাও within bracket. সেন্টেন্সটা কি বলছিলাম বলো তো? Right. Coal India Limited, as it appears from notice -22/2025 dated 24th November 2025 in connection with promotional process initiated under notification -2/2025 dated 25th February 2025. Stop. Next paragraph. 1, 2, 3 করে করবে. Next paragraph. Petitioners pursuant to notification dated yes, whose mobile is ringing, go outside. Please go outside, put it in the silent mode. কি বলছিলাম? Notification dated 25th February 2025. Petitioners করবে, petitioners 25th February 2025 participated in the promotional process for being promoted from non-executive cadre to executive cadre under finance discipline. Stop. In the notification dated 25th February 2025, it was specified that out of total vacancy of 86 under finance discipline, 19 vacancies were reserved for a scheduled caste candidate and 16 vacancies were reserved for scheduled tribe candidates. Stop. Petitioner subsequently participated in computer-based test, which was conducted on 29 November 2025. Stop. Thereafter, vide notice dated 24th November 2025, thereafter একটা করো না। Meanwhile, VDA notice dated 24th November 2025 vacancies reserved, vacancies earmarked against finance discipline. Vacancies earmarked against finance discipline were further categorized under qualified group and semi-qualified group. Whereby three vacancies are reserved under scheduled caste category and two are reserved under scheduled tribe category. Under finance discipline against semi-qualified group. Stop. Petitioners fall under semi-qualified group and it is contended such subcategorization of vacancies under qualified group and semi-qualified group is impermissible, which amounts to change of rule of game during in the midst of selection process. Next paragraph. Learned advocate representing CIL appears on virtual mode and opposed this writ petition on the strength of clause 1.15 of Coal India Limited HR manual. Stop. On perusal of clause, next paragraph. On perusal of clause 1.15, said clause 1.15, it is found that against finance discipline, for departmental selection / promotion, 20% vacancies are reserved, out of which 50% vacancies are reserved for qualified candidate, whereas 5% are reserved for semi-qualified candidate. Stop. Therefore, it appears that such subcategorization of vacancies in between qualified candidate and semi-qualified candidate under finance discipline is provided under clause 1.15 itself. 1.15 itself. Stop. Next paragraph. Prima facie, it appears it is not a case of it is not a case of altering rule of game in the midst of selection process. Stop. Hence, prayer for interim order is refused. Stop. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioners shall be at liberty to mention the matter before the appropriate bench for hearing, after the time fixed herein above for exchanging affidavits. Promotion to be granted in favor of the selected candidates shall be subject to promotion to be granted to the selected candidates shall be subject to final result of the repetition.
And they may, my lord, notify to the selected persons your lordship's order, my lord.
Yes.
They may, my lord, notify your lordship's, my lord, order to the selected person. Otherwise, they may take, my lord, subsequently, if
that steps they will take. Yes, Mr. Sharnal, take steps.
Or may I
Yes, my lord, may I only, my lord, humbly submit, though my lord has stated that it is not a case of, my lord, that maintainability issue if may be kept open.
No,
My
it's
lord.
not a case of maintainability. Sorry.
May I get back the judgment, my lord?
Yes.
Item number 2.
For the petition.
My lord, I am appearing for the respondents.
It is only an interest on delayed payment of the provident fund. Your lordship's order, my lord, I have given necessary corrections.
Yes, retired on
30th of September 2024.
30th September
2024. When a provident fund paid on 30th.
80% provident fund you are seeking.
Yes.
Unpaid 80% provident fund.
Entire provident fund has not been paid. That has been paid on 30th August, 1 year after.
Oh, it's a delayed payment of provident fund, gratuity and
only the provident fund. Gratuity, leave encashment has been paid within time.
Within time. Yes. So you are seeking interest on provident fund.
Only.
West Bengal Transport Corporation.
Yes, ma'am.
You are for the state. When it was paid, provident fund?
30th of August 2025.
এইটা না পুরো কারেকশনস গুলোকে ইনকর্পোরেট করে দেবেন। এইখানে শুধু একটা প্যারাগ্রাফ অ্যাড করবেন তো, মানে প্যারাগ্রাফ 5 একটা অ্যাড হবে। ইন কেস অফ নেসেসিটি government shall provide necessary fund for paying interest in terms of the aforesaid directions, for paying interest to the petitioner in terms of aforesaid directions. তারপরে 5টা 6 হয়ে যাবে, 6টা 7. Yes, dispose.
Grateful, my lord.
Yes, disposed of.
Grateful, my lord.
Number 3.
They appear for the respondent number 1.
Lord, I am for the petitioner, my lord. In this matter, on the last date, my lord, a point of maintainability was raised by my the learned advocate for the respondent, my lord. The respondent before your lordship is the, my lord, PNB Housing Finance Limited.
Yes,
Yes, my lord. My lord, may I, my lord, to demonstrate my year that this respondent will
May I submit this? Not this requires a factual investigation only with regard to the Article 12 point. Kindly permit us to use an affidavit only to that extent.
only on the point of maintainability. Very
But I acceded to that. But my lord, kindly a short period may be given to exchange of affidavit because I have been terminated from the
matter is taken up for consideration pursuant to the order dated 7 January 2026. When Mr. Soumya Majumdar, learned senior advocate representing PNB Housing Finance Limited, has prayed for opportunity to use an affidavit on the point of maintainability of this writ petition. As it is contended on behalf of the respondent, on behalf of respondent authorities, that writ petition is not maintainable against PNB Housing Finance Limited. Stop. Next paragraph. Let affidavit in opposition to this writ petition be filed by, for abundant precaution, you use affidavit in opposition in its end, consider treating this writ petition. It will not be confined to maintenance.
This is opposition to
Affidavit in opposition to this writ petition be filed by 2 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 1 week thereafter. Stop. Let the writ petition appear under the heading hearing. No, stop. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
Item number 4.
That I am appearing on behalf of the respondent.
For the petition in this matter.
On the last occasion, your lordship asked my advocate on record what is the instruction from Coal India in respect of non-granting promotion to the petitioner, my lord.
Just a minute. Yes.
So far not.
What you are praying for in this?
I am praying for the promotion in view of the fact that in 2005, my inquiry has been closed and till date, my lord.
Page 71.
71 at bottom, my lord. So I am praying for the promotion.
But you are not being provided with the opportunity to be promoted.
No, nothing.
Because, my lord, no vigilance clearance is there, no safety clearance is there. So for the safety clearance is concerned, it must be get from the Director of General Ministry of Safety. My lord, what happened due to his?
But it appears to be a punishment in a roundabout way.
So far he has stated that disciplinary.
You could not proceed with the disciplinary proceeding, and the proceeding was closed.
No, not closed. And it is not correct statement, my lord. Proceeding has not yet been closed. and criminal proceeding is still pending.
If the criminal proceeding remains pending, it's the retirement of the
So
petitioner.
far, if that my learned friend is challenging the inquiry proceeding, that cause of action arises at Jharkhand, then, so far the promotion is concerned, promotion be given by the Coal India Limited.
If disciplinary proceedings would have been brought to its logical conclusion, question would have been different. If the authority could not proceed with the disciplinary proceedings and the proceeding was closed, then
closed.
why petitioner will not be? Yes, page 71, come to please page 71.
Not closed.
Instead of shaking your head, please come to page 71.
Yes, Malad.
Please come straight away, come to last paragraph, read it loudly. Let us understand.
Yes, all the charge officer except C. R.C. Das.
No, in view of the above position, page 71 of the writ petition.
71 is so far.
It is signed on 19th May 2005.
Deadlocked and cannot proceed it further. He has therefore no option but to close the
inquiry. Yes. What wrong this court has said? That you are shaking your head?
The case.
No.
The case may be forwarded to the disciplinary authority for taking a view in this matter. Not
when this decision was taken?
7th May 2003.
So 20 years have passed in the meantime?
2005.
20 years have passed in the meantime. This writ petition was filed on 17th of October 2025.
Yes.
What steps you have taken?
So far the papers are not available. Now the inquiry committee has been formed by the director.
After 20 years?
No, after your lordship's order, my lord. In 2026 in January.
An inquiry committee consisting of executives hereby constituted to inquire the matter related to charge sheet issued to Rajesh Ranjan Srivastava, my lord. And
it's a motivated step.
My lord,
it is completely a motivated step. There are order judgments of the Supreme Court that after a lapse of time, initiation of proceedings or revival of proceeding is not permissible. But suppose you have made a charge or you have made certain allegations. Is it possible for a person that what happened 20 years before to recollect?
Malad, so far the belated disciplinary proceeding is concerned, Supreme Court in Banishing's case state if it is a complicated case, then my lord, at the
for 20 years you have not taken steps. When court is in session of the matter, you have done this.
Well, serious kindly appreciate 29% has died due to his negligence. Well, 29% died, spot died. And so far that's why, my lord, the central government, my lord, the director of general mining safety has not cleared the so far the
that's
safety.
Why you could not complete the proceeding. In 2005, it has to be closed. Again, you are saying no. Don't say beyond record.
Yes, my lord.
Please don't say. And you are led by a counsel. Don't raise your voice. Follow the maintain the decorum. I have marked you in other matters too. Don't invite this court to make adverse observations in the order. Be polite, be courteous before this court. I have seen in other matters too. That's why I am expressing my mind.
Well, the case may be forwarded to the disciplinary authority for taking view in this matter.
But why 25 years after a gap of 20 years, this disciplinary proceeding is being tried to be revived? Since court is considering the matter. It appears so. What prevented the authority after 19th of May 2005 to take steps?
Well, it is equally true. My learned friend's client did not challenge the inquiry proceeding also. He has also approached.
Mr. Ghosh, also place your case.
Page 71, my lord, if you kindly come. Page 71, my lord, once, my lord, if you also come. Page 71, my lord. You also will find, my lord, 7 persons were involved. Page 71, my lord.
Yes, 7 persons involved.
My lord, 1, 2, 3, Alok Sengupta. Your lordship, my lord, got it, my lord. A.K. Sengupta.
1 is Sham Sharma.
Number 3, my lord, if your lordship kindly come. A.K. Sengupta.
A.K. Sengupta, yes.
He was also involved. His inquiry also been closed in view of this, my lord, page 71.
Yes.
Now kindly come page 94 of the second volume of my writ application. Second volume, my lord.
Yes, page 94.
94. My lord, I was, my lord,
Promoted.
promoted.
Excellent.
Serial number 3, Alok Kumar Sengupta. In 2007, even, my lord, I was, my lord, from, my lord, beginning of my service, still, my lord, I am working as, my lord, E4.
Executive E4 grade.
E4. Now this gentleman was, my lord, subsequently promoted, and he was
Are hereby promoted to the post of General Manager Mining E8.
E8, last grade. He has
In
been,
E7 to E8.
yes, last grade of, my lord, the executive, the same person, Alok Kumar Sengupta.
Anything more?
No, but these are the main issues.
So you are seeking promotion,
I'm seeking
but
promotion.
you are not being permitted to participate in promotional process.
Only, my lord, one.
Because the system is this as it is found in the previous matter,
Yes.
though that is not in case of ECL, it is a case of CIL.
Yes.
But there is an applications are invited from the
No.
intending candidates.
No, application intending candidate in respect of non-executive to executive. Here I am already executive.
So there the
automatically
promotion is automatic.
Automatic by virtue of my seniority. Now, if you losses kindly come, my lord, page 73.
Yes.
The first volume. My lord, page 72 is in 2012. I have given, my lord, the type copy. 72A, my lord.
Page 73.
My lord, 72, my lord.
Page 72.
72. Here, my lord, the senior manager P of Bharat Coking Coal Limited wrote a letter to the, my lord, to my client that third paragraph, you are once again requested to submit the same immediately, as we are reminded by CIL for the same for consideration of your case of promotion to the next higher grade. So I have to submit some certain documents. Now, my lord, next page, page 73, you also will find this, my lord, executive profile was sent by my employer to the Coal India. Page 74, you also will find.
Page 73, yes.
74, next page, relevant part. You also will find, kindly see, my lord, the next page, page 74, at bottom left hand side. 2008, you also got it, my lord.
Page 74.
74, at bottom, EER, Executive Evaluation Report. At 2008.
EER, yes.
E means, my lord, excellent. Then, my lord, 2014 standing.
Executive Evaluation Report, then 2023.
At the relevant point of time, they have sent my performance as excellent, outstanding, very good, and outstanding. Up to
2008, excellent.
Excellent.
Up to from 2008 to 2013, excellent.
Excellent. Then outstanding up to 2021.
Then very good.
Very good. Then outstanding. Still, my lord, my promotion has not been given. But in a, my lord, situation where, my lord, they, my lord, file a case in a, my lord, by the vigilance department. This is their rule of, my lord, promotional rule. If you lordships kindly see, if it is, my lord, cross 18 months from the initiation of the criminal case, which is pending since 2003, my lord, in my case, my case is pending since.
Serious and fatal but it is a case of promotion of officers who have been connected with serious and fatal mine accident.
Yes, here fatal mine accident. Here also fatal mine accident. Now, my lord, my case is pending since 2003. Now, your lordship will find, my lord, from this, my lord, their own rule. My lord, procedure for issuance of safety clearance.
Where from you are reading?
Your lordship will find, my lord, 2. Thereafter, my lord, the procedure.
The question of withholding.
Thereafter, my lord, the procedure for issuance of, my lord. The, my lord, may I read, my lord, from 2, my lord. The question of withholding of promotion of the officers involved in fatal accident was examined by the Department of Coal in consultation with the DGMS, Ministry of Labour, and CMDs of the coal companies, and in the context of the delays which take place in the completion of the prosecution launched in the court of law it was decided that the question of withholding of promotions of the officers concerned would be reviewed as per the following procedure. The procedure for issuance of the safety clearance of the executive for promotion in a case of pending court cases relating to serious and or fatal mine accidents. The internal safety organizations of the subsidiary shall examine and update the detailed report of safety performance and appraisal of all executives on its master roll on every 30th June of 31st December. Head of the ISO of the respective subsidiary shall put up the above mentioned report of the safety performance and appraisal along with the appropriate justifications to the subsidiary board in every 6 months for consideration of the case and approval for grant of safety clearance in respect of the executives whose case are being inquired by the high powered committee constituted by the chairman CIL or by the court of inquiry under section 24 of the Coal Mines Act. In a case of prosecution loss in a case of court of law for fatal accident occurred in mines, the detail regarding charge of offence and updated status of the court of inquiry shall be proceedings shall be examined to prepare the appropriate justification on case-to-case basis for the purpose of grant of safety clearance by the board of respective subsidiaries. In context of delays, now my lord, here my lord, our case is coming. In context of the delays in completion of the prosecution lodged by the DJMS in the court of law or in a case of inquiry for more than 18 months from the date of filing of the case or start of proceedings by the court of inquiry as the case may be, grant of safety clearance may be proposed to the board of the subsidiary companies along with appropriate justification as per clause 3 of the mentions above by the head of the ISO of the following situations. When an executive concern is not found responsible in ISO inquiry or executive has been exonerated by the DA. So here my case, I have been exonerated by the inquiry officer way back in 2005. Now, when the executive concern is found responsible in ISO inquiry and the penalties have been awarded, but the
ISO inquiry, what?
My lord, the internal safety inquiry, my lord.
Safety?
1 minute. May I ask more? Internal safety organization.
Organization. Just a minute, when executive consent is not.
So, my lord, clause A.
This for internal safety inquiry or execute. Granted by D. The consent is not responsible in ISO. Disciplinary. Yes.
Now, my lord, clause A, but I have already been exonerated by the inquiry officer. Now, my lord, they were after your lordship's order in January 2026, they sought to reopen again, my lord. So I'm asking, my lord, my promotional benefit along with all
text of
financial and consequential effects.
Text of the delays in completion of and delays prosecution. Now it says that grant of safety clearance may be proposed to the board of subsidiary company along with appropriate justifications as per clause 3 mentioned above
Yes. Now, my
by the head of ISO in the following situation.
lord,
Which one is the internal safety organization here? Head of ISO?
internal safety organizations of, my lord, the subsidiary company, my lord. There is a, my lord, another organization in the subsidiary company. My lord, they looks after, my lord, safety and etc. My lord.
Which is that organization?
But in BCCL, my lord, there is separate department under the Bharat Coking Coal Limited.
So petitioner is the executive under Bharat Coking Coal?
Yes. Asking the promotion from, my lord, Coal India.
Yes. Promotion?
From
By
Coal India.
Coal India,
Coal
because
India.
Coal India,
Coal India will, my lord,
holding
give the
company.
promotion.
So far the executive post is concerned, my lord,
Controlled by Coal India.
Only
controlled by the
So ISO is a Coal India. Which
Not
one
con-
is the ISO?
ISO belongs to, my lord, Bharat Coking Coal. And
Now, my lord, because of, my lord, this situation, my lord, they have already granted promotion to Alok Kumar Sen Gupta.
The board of subsidiary. And which one is board of subsidiary?
Board of subsidiaries is, my lord, the
Bharat Coking
Bharat
Coal.
Coking, as well as, my lord, the another board is also there in Coal India. They never send my name before the appropriate authority.
That is Coal India in case of
Yes,
promotion.
yes.
no, my lord, usually what happens, name should be sent by the subsidiary to the holding company every 3 years. BCCL has not sent to the Coal India, therefore Coal India has no occasion to consider the same. And second thing, my lord, if my learned
So
friend
names are to be forwarded by BCCL
to
to
Coal India,
So that has not been done in the present case.
present case. And second thing,
But you are representing Coal India as well as BCCL.
Yes, yes.
yes, and so far, my lord, another thing.
So in terms of this clause 4, you forward it now. There is no impediment in forwarding the name of the petitioner for promotion.
My lord, only thing, my lord, kindly appreciate.
Because it says that
yeah.
you read clause 4. You read clause 4.
Yes, my lord,
There
security
is
in the
similar circumstances, they already granted promotion to Alok Kumar Sen
promotion has
Gupta.
been delayed due to pending prosecution proceeding on fatal and or serious mine accident. The seniority of the officer whose promotion has been delayed due to pending prosecution proceeding in fatal or serious mine accidents and promoted after a review will be determined in the same manner as in the case of officer whose promotion was delayed due to pending departmental or vigilance proceedings. Malar, another thing, Malar, kindly appreciate.
But in terms of this, I am trying to elicit the actual state of affairs in view of this provision, which is placed 1.13 of this cadre scheme and promotion procedures. Now, 1.13 not 1.13, 1.17 general promotion to higher post. Now there it appears that if 18 months have passed, then the promotional process can be started.
Yes.
And the employee or the officer can be promoted to the next higher grade. It says that in the context of delays in completion, as it is found, there is an enormous delay. Now there is a delay of 20 years. In context of delays in completion of prosecutions launched by DGMS, in courts of law or in case of court of inquiry, for more than 18 months from the date of filing the case or the start of proceeding by court of inquiry, as the case may be. Grant of the safety clearance may be proposed by the board of the subsidiary company along with appropriate justification as per clause 3 mentioned above by the head of ISO in the following situations: when executive concerned is not found responsible in ISO inquiry or executive has been exonerated by departmental disciplinary authority.
But one thing I'm asking,
By the disciplinary authority.
I'm asking myself, if my learned friend's client has been exonerated in the 2005, there is no occasion on his part to approach before the authority. They for the first time, approach before the authority concerned in the year 2024.
This is their responsibility to send my name.
Page 138. 137. 137, Mali.
Where is the assessment of the petitioner? You have just shown.
Yes, page, my lord, 72. And my lord, that part is 70,
Page 72.
74. This is their document. They have sent this.
Come to page 74 of the writ petition. This is yearly, EER stands for
Executive Evaluation Report.
Executive Evaluation Report.
Yes, my lord.
Yes, see the EER.
Yes, my lord.
Outstanding, very good, outstanding, then excellent, 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 excellent. E stands for excellent.
Yes, yes.
Excellent.
Excellent.
Yes.
My lord, if himself.
And he will not be promoted when similarly circumstance another candidate, namely Alok Kumar Sengupta, has been promoted. Come to page 71 of this, page 71 of the writ petition.
Lordship.
Serial number 3, A.K. Sengupta. Then straightway come to page 94.
My lord, whether their role is similar or not.
But you have not taken any steps for 20 years. Now court is considering this matter and you are trying to initiate a fresh proceeding in order to frustrate his promotion.
My lord, in one hand, my lord,
but it's max of malafide. I am telling you that when court is considering the matter, you have initiated a proceedings after there was a quietus for a period of 20 years.
Not inquiry proceeding, my lord, only inquiry committee consisting of the executive hereby constituted to inquire the matter related to charge sheet issued within 10 days. Within 10 days, my lord, they will give the report. My lord, kindly.
देखी दाओ तो accident occurred relating to an accident occurred in Bagdigi, Koliari, Lodna area on 2nd January 2021.
And
2001.
And 29% died, my lord.
But you could not complete the proceedings.
Yes,
now court is hearing this matter, trying to find and considering whether there are certain avenues for promotion of the petitioner. Now you are you wake up from some slumber. What is it a reasonable approach so far this statutory authority is concerned?
Well, only thing, well, one judgment is so far the banishing case is concerned, delay so far the disciplinary proceeding. If there is some complicated issue is involved, then at the belated stage, well, disciplinary proceeding may
you are working on as E4 to E5. There is a promotion for E4 to E5.
Yes, now I will be promoted up to E8 because this year I am going to retire.
Well, so far the approach, so far the promotion is concerned, but the approach before the court delay.
When you will retire?
Well, I retired this. Or may I ask my date, my lord? Yes, what date is this? But 31st May 2026.
Well, delay in approaching before the court is also fatal, my lord. So far the promotion is concerned, because well, if we allow him to promote, then well, a topsy-turvy situation will come.
When the matter was last heard?
The matter was heard, my lord, severally, my lord.
January 2026. Then 17 January, this notice was issued. This criminal case is pending.
Yes, criminal case is
there
pending.
is no conviction on.
No.
Till date.
No.
Till date, no conviction, no vigilance clearance is there, my lord. No safety clearance and present status of the criminal case, my lord. Kindly. Till it is at the stage of evidence, man.
Where from you are getting this?
My lord, first, second, third, fourth, fifth, sixth page, my lord. Judicial Magistrate 12, last it was heard on 12 January 2026, and next date of hearing is 12 February 2026 for defense evidence.
But AK Sengupta is one of the accused.
Yes.
How he has been promoted? Yes, Mr. Pal. Petitioner versus respondent AK Sengupta, 5 others. How he has been promoted? Yes. How he has been promoted?
My lord, then
If it is a case of pendency of a criminal proceeding, how AK Sengupta has been promoted?
whether his vigilance clearance was there or not, my lord, I have to take instruction. Whether safety clearance.
Sure. In this writ petition, comma, inter alia, comma, 1, 2, 3, 4, petitioner has prayed for promotion to the next executive cadre in accordance with norms. As the petitioner is presently working in executive cadre in Bharat Coking Coal Limited.
I am paying promotion according to my seniority.
In Bharat Coking Coal Limited, within bracket for short BCCL. Stop. Sentence table পড়ো তো। And seniority. Stop.
Paying promotion according to my seniority. Not
Yes,
on the
that
next
is
grade.
recorded. In connection with an accident occurred in Bagdighi, Bagdigih, Bagdighi, Bagdigih. In connection with an accident occurred in Bagdighi Colliery, Lodna area on 2nd January 2001. A disciplinary proceeding was initiated against the petitioner. Stop. It is submitted on behalf of Coal India Limited for short CIL and BCCL that a criminal proceeding was also initiated against one A.K. Sengupta and 5 others, which is, it is before the Chief Judicial Magistrate?
Yes, yes.
Which is before the Jurisdictional Chief Judicial Magistrate? And next date is fixed on 12th February 2026 for defense evidence. It is contended on behalf of respondent authorities that petitioner is one of the accused in the said criminal proceeding. Stop. Next paragraph, from the submissions made on behalf of the parties, it further appears that a disciplinary proceeding was initiated against 7 officers of BCCL in connection with the accident occurred on 2nd January 2001 in Bagdigi Colliery.
I may be excused, I will excuse, serial number 1 and 2 is my lord the inquiry officer and presenting officer. Rest are my lord the accused. I may be excused, my lord.
Page 71.
Page 71, my lord. 1 and 2, just now I my lord noticed, right hand side IA and P.
Right.
My lord.
হ্যাঁ কি বলছিলাম সেন্টেন্সটা বলো তো। না 5. Stop. However, it is found from page 71 of the writ petition that in the month of May 2005, inquiry officer found that inquiry officer found that there was impasse in inquiry proceeding, which could not be proceeded further. Stop. Finding no other option, inquiry officer closed the inquiry. And it was endorsed on 19th May 2005 that case might be forwarded to the disciplinary authority for taking a view for taking further steps. Stop. Next paragraph. It is submitted on behalf of the petitioner that one A.K. Sengupta, Deputy Chief Mining of Executive, CME,
Yes,
Deputy Chief Mining Executive
ECL, my lord. Not Bharat Cooking.
of ECL, who was similarly circumstanced, like the present petitioner.
Well, my lord, he is the officer of
ECL, but he is accused in the criminal proceeding as well as proceeding was initiated against him.
He was
That is, to that extent, there he is similarly
My lord,
circumstanced.
no,
Please, yes,
my lord,
please
board,
take your
board,
seat. Yes,
board is different, my lord.
yes, yes. কি বলছিলাম? Against whom criminal proceeding as well as disciplinary proceeding, criminal proceeding is pending and disciplinary proceeding was initiated. Was favored with promotion from E7 grade to E8 grade. Vide order dated 1st July 2017. Whereas petitioner has been denied promotion on the count of pendency of criminal proceeding. Next paragraph. It further appears from a document at page 74 that the performance of the petitioner was assessed from 2008 to 2023, from 2008 to 2023. Either excellent, E stands for excellent, either excellent / outstanding, assessed as excellent / excellent within bracket E code, bracket close / outstanding within bracket OS / very good within bracket VG stop. Therefore, it is contended that there is no impediment. Therefore, it is contended on behalf of the petitioner that there is no impediment in granting promotion to the petitioner as per seniority. And in this regard, reliance is placed on clause 1.17 within bracket small h within bracket Roman small 3 within Roman small 3 within bracket 4 of cadre schemes and promotion procedure. Next paragraph. On behalf of BCCL and CIL, prayer of petitioner for promotion during pendency of criminal proceeding is opposed and it is submitted since there is no vigilance clearance
and safety clearance.
At this stage, petitioner is not found fit to grant promotion.
And my lord, another thing, petitioner has approached belatedly, my lord.
Stop. আচ্ছা ওপরে ওই এইটা এদের সাবমিশনটা পিটিশনার সাবমিশনটা জানলাম it is contended, it is also contended on behalf of the petitioner that he is going to retire on Mr. Ghosh
May 2026.
going to retire on 31st May 2026. তারপরে আবার এদের
My lord, I have submitted that belatedly he has approached at the fag end of his service career. my lord.
it is also submitted on behalf of respondents that though departmental inquiry was closed on 19th May 2005, but just before his retirement, petitioner has approached this court with the present writ petition claiming promotion. As a result whereof, writ petition needs to be dismissed on the ground of delay. Stop. It is also next paragraph. It is brought to the notice of this court that when court is in session of this matter and passed an order on 7 January 2026, subsequent thereto, director within bracket HR BCCL video office order dated 17 January 2026 constituted an inquiry committee having 4 members to inquire the matter relating to the allegations made against the petitioner in connection with accident which took place on 2nd January 2001. Stop. Copy of the office order dated 17 January 2026 is taken on record. Next paragraph. Next paragraph. Question crops up. If departmental inquiry which was closed by the concerned inquiry officer on 19th May 2005
August, my lord.
and there was 19th May 2005 page 71 and there was quietus for a period of nearly 20 years whether mere pendency of criminal proceeding
19th August, man.
19th May mere pendency of criminal proceeding executive just a minute inquiry officer signed on 19th May.
Well, kindly
Sham Sharma inquiry officer signed on 19th May.
well, kindly come to very next line. Other are signed, my lord.
Yes, but inquiry officer signed on 19th May. হ্যাঁ কি বলছিলাম
August. Perhaps, my lord, it is illegible. That's a 19th August. Well, kindly see that
9 a right of the petitioner to be promoted
19th August
to the next to the higher cadre under executive grade or not. Stop. Next paragraph. Answer is found . Under answer is found in clause, it is second paragraph, next paragraph. Answer is found in clause 1.17 within bracket small h, within bracket Romans 3, then English 4 of cadre schemes and promotion procedures, which is quoted below. এই যে এই পেজটা এইখান থেকে এটা কোট করে দেবে, এটা ঠিক আছে। এটা আইটালিক্সে করবে আর কোট আনকোট করে দেবে, একটু স্মল স্পেসিং দিয়ে। It is provided in clause 1.17 যেটা দিয়ে দেবে within bracket h, within bracket 3, within bracket 4, English 4. In the event of continuation of criminal proceedings, launchটাকে করো initiated by the department in courts of law and in the event of delay of more than 18 months from the date of filing of the case or the start of from the date of filing of the case, grant of safety clearance may be proposed to the board of the subsidiary company along with appropriate justification as per clause 3 mentioned above. When the executive concerned is not found responsible in ISO inquiry or executive has been exonerated by DA. By DA, D full stop A. So, in the present in the present case, though the criminal case was initiated, though the criminal case was filed on 20th November 2003, the same has not been disposed of till date, and more than 20 years have passed in the meantime. Stop. DCPA proceeding was initiated against the petitioner, which was closed as it appears from page 71, as it appears from a document at page 71 of the writ petition on 19th May 2005.
19th August, kindly see page 71.
Other officers against whom proceeding was initiated, they received it on 19th August. But Sam Sharma,
Well,
inquiry officer,
typing.
signed it on 19th
Well,
May
kindly
2005.
see typing, date, upper portion, venue, next is date, 19th August. Venue, next date, time. Date is 19th August, my lord. Record করেছে।
19th August সব জায়গায় করে দেবে তো 19th May বারবার বলছে চেষ্টা করছে বলার। সইটা কিন্তু 19 যাই হোক 9 বলবে ওকেও বলবে ও নিয়ে চয়ন করলে 19th August হবে সেটা। হ্যাঁ কি বলছিলেন?
Disciplinary proceeding was initiated against the petitioner. It was closed as
On
it appears from the
and there was quietus for a period of more than period of nearly 20 years. Stop. It is also found that one A.K. Sengupta, Deputy Chief Mining Executive, ECL, being similarly circumstanced like petitioner, was granted promotion. Video order dated 1st July 2017 from E7 grade to E8 grade, capital E-8, এরকম ভাবে হবে, E8 grade.
94.
Therefore, E8 grade, stop. Therefore, there is no justification in withholding promotion of the petitioner, taking note of the fact that petitioner is going to retire on 31st May 2026. Moreover, performance of the petitioner was assessed in a fashion as it appears from a document at page 74 by the concerned respondent authority, which does not impede promotion of the petitioner. Since petitioner's performance was assessed in between 2008 and 2023 as excellent within bracket E / outstanding within bracket OS / very good within bracket VG / VG full stop. Next paragraph. On perusal of the order dated 17 January, office order dated 17 January 2026, copy of which is placed before this court today, on perusal টা কেটে দাও, পুরো সেন্টেন্সটাই কেটে দাও। Office order dated 17 January 2026, smacks of malafide. Stop. There was no steps. There were no steps taken after closing inquiry on 19th August 2005 for a period of 20 years. And the present writ petition, which was filed on 27th October 2025, was last heard on 7 January 2026. When on behalf of Coal India Limited accommodation was prayed for to obtain instruction. Stop. As the prayer for accommodation was made by the learned advocate representing Coal India Limited, same was allowed and matter is fixed for further hearing today, 21st January 2026. Stop. In the midst, after order was passed on 7 January 2026 and before considering the matter today, 21st January 2026, on 17 January 2026, after a period of 20 years, a decision was taken by issuing an office order to constitute an inquiry committee in order to revive the inquiry proceeding. Stop. Stop. Such step as it transfers from the said office order dated 17 January 2026 is nothing but a ploy to frustrate transfer of the petitioner. Since petitioner is going to retire on 31st of May 2026. Stop. Office order dated 17 January 2026 stands set aside. Stop. Next paragraph. Concerned respondent authorities of BCCL and concerned respondent authorities of Bharat Coking Coal Limited and Coal India Limited are directed to grant promotion considering seniority of the petitioner at an early date but not later than 8 weeks from the date of communication of this order, in terms of norms relating to promotion. Stop. Next paragraph. The writ petition stands disposed of urgent xerox.
Petition is entitled for all back wages and
that is automatic. At this stage that should be.
Only one thing, if you kindly record, the learned advocate submitted on behalf of the Coal India as well as BCCL, because both are appearing.
Yes, I have recorded.
No, your lordship recorded Coal India because
at the now I have directed respondents, concerned respondent authorities of Coal India and BCCL, and previously I have recorded.
Item number 5.
We have for the respondent. On last occasion,
আচ্ছা শোনো
আপনি একটু বলে দিন তারপরে আমি বলবো।
Yes.
Kindly see your lordship's last orders, my lord. Your lordship's kindly see your lordship's last orders.
Last order?
My lord.
What is the date of last order? 7 January?
Yes. Before that, there are also
6.
not, my lord, end. So, I don't add that, my lord. Otherwise, my lord, they will not give.
And release consequential benefits.
And financial benefit. I'll add one financial, my lord.
No, আর কিছু না, consequential. Yes. Yes, there was a confusion with regard to date of birth.
That has been, your lordship,
date of
directed that the matriculation certificate is to given, my lord, preference.
That has
So
been
on that
resolved, my
ground,
lord.
my lord, they have initiated.
Regarding age, there is no uncertainty. That has been resolved, that matriculation certificate will be accepted for the purpose of determining age.
Then
My lord, only in the last occasion, it was submitted by us that under the revised scheme, it will go to a screening committee constituted from the members of both bi-party, that is CIL, ECL, and the workers union, for streaming line of the appointment. But from your lordship side, it was pointed out that revised scheme will be effective from which date?
Yes.
In this case, petitioner was terminated on medical ground on 15th. It's true that it was effective from 1st July 2016. My lord, during the process time, for any reasons, the employment was not given. And to the last communication we made to the petitioner to give some information comment as regards age, that is in the year 2018. Now, my lord,
But why?
Since my lord, since
Benefit of employment after petitioner was declared medically incapacitated by Apex Medical Board in 2015, why the petitioner was not appointed when father was declared medically incapacitated? For your delay, why the benefit will be extended to the authorities?
my lord, not due to age factor, is embargo for employment. Only for the screening committee has not yet formulated the execution process, how it will be affected. Union also involved. But it is true, I am honestly submitting that rule, it was effective from 2016, not 2015. I am honestly submitting. But when the employment was not given at that time, so under the present scheme, it will fall. That is the management stand, my lord. That is why it was not given. And the petitioner.
As per 2016 rules, there is no provision for giving appointment. What is yours? What 2016 rule says?
As per 2000, that time he was eligible for consideration.
Yes, he was entitled for consideration.
At that
in
time.
2015 or 2016?
2000, during that time, at the time of termination, he should have been considered under previous rule.
That is the rule of which year? 2009?
Not 2000, I think 2011. On scheme is valid for 5 years. I think it was 2011 or 12 that scheme was made, and it was effective up to 2015. And thereafter new rule was framed.
As per National Coal Wage Agreement of 2011, petitioner was eligible when father of the petitioner was declared
unfit.
Unfit.
Right.
But in what was the situation in 2016 as per 2016 wage agreement?
as per 16 wage agreement, it will go to a screening committee. It is made from the members of the CIL, ECL, and the workers union. They will make formulation, policy implementation, instruction. That instruction has yet to come in this case. That is why it was kept pending.
Happened to other candidates who were found eligible in terms of 2011 policy?
But I have no figure in respect of that employees. I do not know.
There is no filing of affidavit.
Mm.
In this matter, you have not filed any affidavit.
No, we have not.
My lord, till date, the rule is there. Even in 2015, there was rule. Today itself, there is also rule, and they are providing employment. And I have, my lord, the example to my lord, so to your lordship, even appointment letters.
Well, you are waiting from 2015.
My lord,
Did there be exchange of affidavits?
my lord, your lordship has already decided.
Because there are certain changes with regard to the.
There is no changes, my lord. I have all the rules. If your lordship kindly allow, my lord, to place, my lord, the
I am
NCW.
recording your submission that the date of birth which is recorded in the matriculation certificate is to be
Yes,
taken into
yes.
consideration while considering the candidature of the petitioner for appointment on compassionate grounds. But since there was a changes brought in by 2016 rules, you file an affidavit. Indicate the changes.
Well, may I submit one thing? Kindly record his submission that he was eligible in 2015 and let they consider. Because they will provide. They will provide. Because if you lordship kindly see, my lord, all these judgment orders, my lord, single bench, division bench, Supreme Court. And
What does it say?
for consideration, they have, I have also, my lord, given, my lord, the appointment
In
letter.
terms of which rules?
Same rule.
The rules which were prevalent at the time of
Till date rule.
declaration of service
There are,
or declaring medically incapacitated or at the time of consideration of candidate.
my lord, there is a no change of rule. Rule that
In
was
other matters, I have found that there is a change.
no. There is no change of rule. Kindly see the appointment letter date. Latest rule kindly see, my lord.
My lord,
দাঁড়ান, আমি কনফিউশন করে দেবেন, কনফিউজ করেন না, আমি দেখাচ্ছি আপনাকে, দাঁড়ান, আমি করে দিচ্ছি। লেটেস্ট রুল, my lord, kindly see, my lord.
That relates to appointment of the petitioner. Now,
Well, let they consider, my lord.
father of the petitioner were medically incapacitated in 2015. Stop. Thank you. Initially, there was a dispute with regard to reckoning date of birth of the petitioner.
Three appointment letters I have given to you, my lord, of 2024. All are same issue. I have also given.
As different date of births are recorded in the service records of the father of the petitioner, as different dates of birth are recorded in service records of the father of the petitioner and matriculation certificate of the petitioner. Next paragraph. However, learned advocate representing ECL or Eastern Coalfields Limited has submitted an information that date of birth as recorded in matriculation certificate is to be taken into consideration while considering candidature of the petitioner for appointment on compassionate ground.
Yes.
Next paragraph. However, it is pointed out on behalf of ECL that during that
in the meantime,
that meanwhile there is a change in rule relating to appointment of a dependent family member after an employee is declared medically incapacitated by the Apex Medical Board. Stop. Next paragraph. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this petition be filed by 3 weeks from date, stop.
3 weeks.
Affidavit and reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph, petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. That's it.
Grateful, grateful.
Final order must be on evidence.
Yes, yes.
Normally, I do not pass
Yes,
an
yes.
order to file a report unless and until there is
Well,
specific
no problem.
urgency. You take back compilation of the orders.
Very well. Report take yes, sir. Item number 6. So here, my husband was
Your Lordship had
Missing.
granted me the leave to file the affidavit, Your Lordship, because I had misplaced my earlier affidavit.
Reaffirmation.
But I have found my old affidavit, Your Lordship. I have not reaffirmed it now. I am filing the older, they have already filed a reply to the same.
Learned advocate representing Eastern Coalfields Limited has submitted, though he was granted by this court video order dated 17th December to reaffirm affidavit. As original affidavit was lost. But today it is submitted by the learned advocate that original affidavit was found out. Stop. Affidavit which was affirmed previously is filed today and same is taken on record. Stop. Next, as the affidavits have already been exchanged, matter needs to be treated as hearing matter. Stop. Let the matter appear under the heading hearing in the monthly combined list of March 2026.
Good night.
You have already filed reply.
yes. Well, only one thing, my lord, admitted dues may kindly be, my lord, released because in their affidavit they have already admitted, paragraph 18, that they are agreeable to release the admitted dues because
In that
husband has died.
whatever is made in accordance with the applications.
Para 18 of their
released.
report.
What is a matter relating to release of terminal
Yes,
benefits?
my lord. Terminal benefits. Paragraph 18, my
Why
lord.
this was withheld?
Because my husband was found missing and subsequently I filed a, my lord, suit for declaration of civil death.
7 years have passed.
Yes, civil death also been declared. Now, my lord,
For
there are,
that we have preferred an appeal, which in title appeal, the matter is pending.
but there is no stay. But ultimately, civil court has, my lord,
What are the admitted amount you are claiming?
my lord, the provident fund, pension and other gratuity, everything, my lord, nothing has been released. And paragraph 18, kindly see of their report.
If provident fund and gratuity is released, in that event, where is the difficulty in releasing pension or other benefits?
Yes, everything has to, because they have admitted, paragraph 18, kindly see. Well, may I read? The terminal benefits such as provident fund, gratuity and pension are statutory benefit payable as per the relevant action rules. The respondent management is ready to process the release the retired benefits subject to the petitioner submitting all relevant documents. So I will submit.
Your Lordship, that now the dispute is regarding the date. We say that it is to be, what date it is to be. I'll take instructions on this
No,
para
no,
18. What is the date till which they will be releasing it, Your Lordship? And I'll come back on the next date regarding the same.
No, whether the husband of the petitioner is to be treated as dead person or not, that is the issue. Now, if you release from a particular date, then why the entire benefit will not be released? Because there is no other issue.
No.
And in the meantime, if 7 years have passed, then in terms of the relevant provisions of the Evidence Act, the person is to be treated as a dead person.
Yes.
Your Lordship, he worked for a very limited time, and that is the reason we have preferred the appeal, because the civil court had declared that he died in service. It is deemed that.
Yes, 7 and 8. A civil court already declared, my lord.
Your Lordship, so our title appeal on that subject matter is pending.
Whereabouts of the person is not informed or not known for if more than 7 years, then he is to be constituted as dead person. See, if that is so, then where is the difficulty in releasing?
Your Lordship, but the court has directed, the trial court in its order directed that he died while in service, and these are the legal heirs. So while in service, regarding that, we have preferred an appeal because it is not that he died in service. Because there are other consequential reliefs that he
Died while serving, he did not die while serving.
Your Lordship, he was missing. We terminated him after following the due process of law. Page 10 is my termination letter that we had issued against.
Which order you preferred appeal?
Your Lordship, page 28 is the order. Page 27 onwards. Page 20 of the opposition filed by me, Your Lordship.
It's also annexed in the rate.
We put in the form of question. Page 28.
Page 32 is my appeal.
Yes, this decree was passed on 10 January 2024. Then
Your Lordship, page 32 is my appeal, title appeal that I preferred.
page 30.
32. Title appeal 17 of 2024. In that page 33, ground number 9 and 10, I had specifically pleaded that the advocate was not present when the decree was passed, and we could not even commence our arguments and produce any documents.
And also kindly 6, my lord, the Roman 6. The Samsundarpur Colliery had lodged the missing diary. Even Colliery also lodged the missing diary.
What has happened?
Your Lordship, page 31 is the Your Lordship, page 31, I have given the order of 18 December 2024.
What is the present status of this appeal?
Your Lordship, this matter was last taken up on 18th of February 2025 for it was returnable for service return. Your Lordship, I'll take the latest status as what is the next date for the hearing, and page 31, I have annexed the 18 December 2024 order. It was fixed on 18th of February.
Why you are disputing the date of the petitioner, husband of the petitioner?
Your Lordship,
specific provision under 107 of Evidence Act. Why you are disputing this?
Your Lordship, because the court has passed an order that he died in service while, and it is deemed that he died in harness while in service, second paragraph at page 28, Your Lordship.
No, court has said the husband of the plaintiff, namely so and so, will be deemed to be died regarding all legal purposes, and he has died while in service. Yes, in service candidate died.
Yes. But page 33, if you kindly come. Page 30, my lord. I was missing from on duty, my lord. That's why they have lodged complaint before the police. This is their admission in their appeal before the court below, page 33.
From which date the husband went missing?
My lord, kindly come page 33.
What is the date of missing?
My lord, 11th February 2004. And they have lodged complaint before the police. From duty, I have, my lord, kept missing, my lord. Kindly see, Roman 4, kindly see.
Lordship, page
For that, the Samsundarpur Colliery,
Page 33.
page 33, this is their memo of appeal,
Yes.
annex in the opposition. For that, the Samsundarpur,
Which ground?
my lord, 6, my lord, Roman 6. For that, the Samsundarpur Colliery had to lodge the missing diary on Atho at the Ondal police station, at the local police station Ondal. So they itself made intimation as I was in service.
and page 10, Your Lordship, we have given the letter.
The widow is lamenting
Your Lordship,
from 11th of February 2004.
Your Lordship keeps it in the February monthly list
No,
or
next Wednesday.
next Wednesday, Your Lordship.
Sure.
I'll take instructions on that.
There's a direction to file a report in the form of.
Lordship.
Yes.
Report change করব। ওই পার্টটা পড়তে হবে না, ওটা তো হয়ে গেল। হ্যাঁ এইখান থেকে কেটে দিই, কেটে দাও। Affidavit in the form of report is filed today on behalf of Eastern Coalfields Limited, and a reply to the said affidavit also in the form of affidavit is filed on behalf of the petitioner.
Last day I have filed.
Oh, acha. আরেকবার সিরিজটা করুন।
Exception to the report.
On behalf of ECL and same is taken on record. Stop. Next paragraph, list the matter under the same heading on Wednesday next. 28 January 2026.